it on 13th. So, my lord, after the matter was mentioned, we came to know that this is a tender appeal, my lord, coming from the interim stage, my lord. I have been disqualified from the technical bid, and there are all possibilities that I will succeed in the writ petition, my lord.
So what can be done? Tell us.
My lord, kindly take up the matter on Thursday or Friday, my lord, because the on 13th, my lord, the matter has been picked by the learned single judge, my lord. And in order not to create any third party interest, my lord.
Yeah.
Okay, Friday.
Obligement.
May I please, your lordship? Lordship, I'm trying for listing a matter, lordship. This is PIL matter pertaining to Nagaon district, lordship.
Fresh or old?
Fresh one, lordship. We have filed yesterday and we.
Nagaon. What happened in Nagaon?
Lordship,
What happened in Nagaon?
we will be evicted, lordship.
You will be evicted.
Yes, lordship.
Evicted by whom?
By the forest department, lordship.
Forest.
Yes, lordship.
It's a
You are a forest dweller.
wildlife sanctuary, my lord. There.
You are, either you become part of the wildlife, then you can stay there. If you are not part of the wildlife, then you have no business to be in the wildlife sanctuary. Except the forest authorized personnel who will detect smuggling, detect poaching. Are you part of that?
Lordship.
Are you, is the PIL petitioner also evicted? Likely to be.
Likely to be evicted,
You
lordship.
You will file a writ.
you are the victim or the potential victim or just a social worker? Are you a social worker or a potential victim?
He's an advocate.
He is an advocate, lordship.
Oh, advocate. Give one
that.
good, give his name, will include in the legal aid service. Will lawyer advocate. I thought they'll be busy in the court running around doing legal. He is going to wildlife. Those persons will come, let them be represented. We'll see that. We'll see that.
Lordship, eviction is tomorrow.
Eviction is tomorrow. How many people you think? See, you are taking a risk. If it is
If the parties
See-
are agreeing, they can come. Go the
see, who are those people who are likely to be evicted?
Lordship, the contention is that they are not residing in forest area, your lordship, and they're
Yes, no, then a very good law case, you go to writ and file a writ petition immediately. Instead of PIL, you file a writ petition that yes, I am a settler of my own patta land, not the forest land. Government is declaring every land to be a forest land.
but
Tomorrow they will declare Khargul a forest land and we will be also evicted. You say that.
notice has been issued, your lordship,
Notice
and
When was the notice issued?
notice issued on 25th, your lordship,
25th of
January, your lordship.
January. Then you celebrated 26th January. And then you could have come immediately.
There are multiple schools there, your lordship, and exams.
Schools
are
also?
tomorrow.
School also in wildlife sanctuary. I don't know what is happening. Additional Advocate General, I don't know what is happening. We don't know.
Well, it's called.
You allow all these schools to function in Kaziranga inside all those ones.
In fact, this Laukha Wildlife Sanctuary is a part of extension of Kaziranga National Park, man. It's a tiger project also. So we have issued notice to them, they have to be evicted because they are admittedly, they are encroaching. From the map, we can trace out, there are.
See, for eviction notice, you must be having some eviction as some public premises. Do you
forest,
resort to?
in forest, there is a provision for making a rule, but rule has not yet been framed.
You should frame the
But
rule also.
a law is absolutely settled, under the Forest Conservation Act. Forest land cannot be used for any non-forest purpose,
Correct, that is correct.
And Forest Rights Dwellers Act also says, there has to be an occupation of 3 generations.
But why can't these individuals come? School means It being meant by some teachers, teachers mean educated, teachers mean there must be B.Ed. I don't think that there can be a teacher only being a matriculate. There must be a teacher, a headmaster must be there of the school. There must be graduate, I suppose. And if you are graduate, you can't come on and you engage a lawyer to file this PIL.
My lord, we conducted an eviction in Lamding Reserve Forest. Therein we found, my lord, churches, temples, everything were constructed there, my lord. And everybody has been evicted. In fact, this court, honorable court, repeated it, my lord. Now, my lord, Nessar is reclaiming, my lord, we are
You'll have
fighting.
to, under the new, at least, land acquisition law, you have to give them alternative accommodation.
My lord, that land acquisition is for only for revenue land, my lord, not
That's
for.
correct, but what is the problem in accepting the principle? You say there are no rules framed under the
Well,
forest.
why don't you frame the rule? That is what also that.
Our principle is, my lord, we evict them and we take them under the land policy, my
You
lord.
can't say that we'll evict them, let them go wherever they want.
Well, we are following the Godaburam's judgment by honorable
That
apex
is
court.
okay, but these people had settled right under your eyes for how many years?
And you give recognize the school also. Is the school recognized?
My lord, that will be a negative
Yes,
equality,
your
my
lord.
lord.
Huh?
That is true, my lord, they have settled.
Negative equality,
Now
we're
it's
talking
schools.
about human lives here.
Yeah,
Yes, my
school is
They
recognized
will be
school.
covered under the land policy, my lord. They will be
That's
getting
right.
that settlement, my lord.
So
Under
that's,
the
who's going to take care of that?
state will take care of, my lord.
So where is the state? Let us
I-
hear the state.
Yes, well, we are the
You
state,
represent the state.
we have, my lord. Even in Lamding also, my
No,
lord.
no,
there-
that's what I was asking you. If you're evicting them tomorrow, is there a
Land po-
proposal?
There is a land
already?
policy, my lord, that will be covered for them, my lord. They will be identified, my lord. If they are really landless persons, my lord, they will be considered for revenue land, my lord, not forest land, my lord.
Naturally.
That is, in fact, that is the actual course of action that we are following, my lord.
But then see, we are not very inclined to entertain PILs filed by lawyers. Okay, lawyers are doing a very good job. Lawyers used to fight for freedom struggle. In India, we got freedom because most of the leaders were from this profession. So we are proud of this profession. But as lawyers, this professional requirement has changed after independence. After independence, we are not required to do these jobs. Therefore, basically for landless people, correct, had it been landless, some tribal people who do not know ABC of law, one can understand, a lawyer can do also. But here you say some schools are running. The management must be there. The teachers must be there. And you think that they cannot, what is the basic PIL? The whole concept of PIL was because those who cannot speak on their own, the locust now is taken up by somebody on their behalf. The poor, the deprived, the underprivileged who cannot speak. Now, they are the one who running a school and you say the PIL. Then you may see we can tomorrow, but then it may be liable to be dismissed with heavy cost. Take the risk. We can, but if it is filed by those, potentially, victims, potential one can understand. You run the risk also. We can list tomorrow. Tell us. Or you file by the potential victim before the appropriate forum. Yeah, approach. Why not?
Why have they not approached?
Why? PIL does not endow with any other extraordinary power. The power of the court remains in the writ jurisdiction.
There are thousands of people, your lordship, and
At least few,
At least 5, 10 can.
5, 10, thousands. And what have been these thousands doing since 25th of January?
Notices must have been issued.
yes, yes.
Then
2 weeks. You have received on 25 and now you're coming just on the nick of the hour and PIL. We have all great respect for this jurisprudence. This is a jurisprudence which distinguishes Indian judiciary from others. Unique, but for a purpose. To defend the defenseless. To speak for those who are voiceless. But normally, therefore, we should keep that PIL also in mind or some of great public importance. Something which cannot be espoused by individual. There may be categories. You know that Uttaranchal, what Uttarakhand case, no? That. So you have all those.
one thing.
So all those things are there, but then you see, identified persons, none of them comes. And this lawyer, he should practice in court, not in wildlife sanctuaries. Tell us, what do you say? Tell us.
Lordship, may kindly hear us once, your lordship, because if tomorrow it is not heard, your lordship, then they would be liable to be evicted.
That is what law has to take his own course. We cannot come in the operation of law also. But you are taking a risk. You still have 24 hours to file appropriate. If you say, yes, we are the landless, we are the original, even mention also, we can do it, take it up. If it is so urgent. But lawyer coming and saying this, we don't know. Credential of the lawyer, we don't know.
Had you not been served with a notice, we could have understood.
Understood, yes,
The
correct.
Notice you have received, you have set over the notice.
See a good natured lawyer while driving from Guwahati to Nagaon, he saw this happening, so he intervened. I will commend such lawyers. Who is passing by and he saw all these things happening, he brings to notice of the court.
In fact, my lord, after the notice, my lord, most of the people have already left, my lord.
See, in that case, you will be visited with heavy fines. Maybe, I am not saying that. Don't think as a threat. No, nothing is. But we are saying these are all possible consequences. We welcome PIL, no problem.
So we are not dissuading you.
You can
What we're
file.
saying is if the persons affected are available,
Ah.
then the proper remedy would be to come and approach the writ court. Because in a PIL, to stay a process of eviction without hearing the other side may not be proper. We'll have to hear the other side.
No, if you say yes, only notice was given by phone or by loudspeaker, now we can understand. Okay, you can't do like that. But you had a notice, paper, black and white. You had all the time to consult lawyers on 25th of January. Okay, 26th January, everybody is celebrating. 27th of January,
Your lordship,
28th of January.
we will consult your lordship, and if they are able to come, we'll come by tomorrow, your lordship. Or we'll make a mention tomorrow.
Okay, make a mention tomorrow. Whatever. Don't think that we are dismissing or we are against you. No, don't say that. Huh?
Yes, sir.
Don't go away with that hope. Oh, court to interest nahi. Court was against us. Don't go with that feeling. Court will be always helpful. Our door is always open. But thing is that we have to abide by the norms, judicial norms, precedents which are set up, isn't it?
Lordship.
So if the victim is identifiable, easily identifiable, who can speak on his own, then perhaps PIL may be a difficult. We were suggesting. So we are just giving what we are reflecting is the law, not our opinion on anything. There is nothing, no new opinion about PIL. But you see the jurisprudence of PIL. Okay. Next.
Yes, please, your lordship. Lordship, I beg to mention for listing of matter.
And
Listing of matter.
what matter is that you want to be listed?
It's a review petition, lordship. The
Review.
matter was last listed on 20 January.
20
Kindly
January.
the matter will be listed on 13.
13. 13th of, that is February. Why not 15? Why not 16?
15 is also fine.
15 also fine.
Lordship, also my senior name, Mr. R. Chakravarti, is not reflected in the cause list. Kindly.
Oh, it is not listed, how it will be reflected?
Let the
It
matter-
will be,
It was last listed on 20.
last week it was 20, it was not reflected.
Let the matter be listed.
Was any date fixed or just adjourned? Huh? I have no idea. When it was listed on 28th, did you make any mention?
Lordship, I did not make any.
You didn't make any mention. And what is the urgency? Do you have any idea?
No, no.
Madam, you should know you can't say, I want to drive this car, but I don't know what car make is this. You can't say that. You should, if you're a driver, you should know, I am driving an Ambassador, I am driving a Mercedes, I am driving a Maruti. Because then you can drive properly. Because the skill you have learned for driving Ambassador cannot be applied for driving Ambassador, Mercedes. Okay. So you should know the nature of the case. At least you should know this is the nature of the case. I was there. You don't just make mention like that. You should know basic. We are not asking you to argue the case. Why it was 28, it was not, then it was why it was passed over. Did you make a mention for passover? Did the other side ask for? Or you didn't, nobody came, so it was passed over. If nobody came, it was passed over, then you don't listed like that. You can't just go around, okay, matter is pending before the court, nobody comes, it get adjourned. Then you say, no, it be listed. Sorry. We don't have time for those lawyers who do not have time for the court. So we have to give precedence those important ones. Therefore, you have to say what is the importance of the case. Do you have any idea why it is mentioned? Why you want 13? Why not 15? Why not 13 of next month? Because you are young, right? That's why we are telling you so many things. If Mr. Digonto comes, Mr. Chaudhary comes, we will not say all these things. Because they are veterans, they know. But you should also, you are young, you should know. Whenever you make a mention before the court, you should know the basic background of the case. What happened last occasion? What is the matter about? Why you are mentioning? These are basic facts the court would expect to know. We would like to know also. Otherwise, everybody will come, make a mention, okay, list. We are not post office. You make a mention tomorrow, okay, after knowing about the fact of the case, as to what happened on 28th when it was listed. Who was responsible for adjournment? And why you want an early listing on 13th? If it is urgent, we'll take it up. So you go back today, see the file, and make a mention tomorrow. Will you come tomorrow or you will not come tomorrow also?
I'll come, my lord.
You'll come tomorrow. What is your name?
Remind JP.
So you come tomorrow. Remind Jaydev, don't fall sick tomorrow. Okay, come tomorrow. Make a mention. Yes, next.
Daily list for motion item 1.
What is this PIL?
Your Lordships, this PIL pertains to illegal sand mining activities and forest cutting activities in the forest of Gwalpara district, Your Lordship.
Lot of illegality is going on in Gwalpara.
Your
And
Lordship.
who are you?
I am a resident of Gwalpara district, Your
Gwalpara
Lordship. I
district.
have gathered most of this information on my own
Okay.
by interacting with other persons also, Your Lordship.
Who was there engaging illegal sand mining and tree cutting?
Your Lordship.
Yes,
I have any
Mr.
photographs also, Your Lordship.
Lot of illegality is going on.
My lord,
Yeah.
let us first see, my lord, what is the petition about, my lord. My lord, may kindly come to paragraph 9, my lord.
Paragraph 9.
My lord, it's not a public interest litigation, my lord, it's a private interest litigation.
Why you say it's a private?
I'm coming to it, my lord. Paragraph 9, my lord, will see.
Yes,
Sorry, 8, my lord.
yes.
That the petitioner sincerely begs to state that the petitioner is aware about mining permits granted to several persons by the divisional forest officer of Gwalpara without resorting to any competitive bidding process. Then my lord will see. As an example, the petitioner begs to highlight the incident.
Para.
Para 8, my lord, page 7.
Okay.
They say, my lord, there was no bidding. My lord, permits were issued. Page 8, my lord. As an example, the petitioner begs to highlight the incident of grant of mining to one Sri Deepak Rava. My lord, kindly take note of this person, my lord. Sri Deepak Rava from Dudnoi River, Sen Mahal number 3A, covering an area under Rongjuli Range. The said contract was granted to Deepak Rava without any competitive bidding. Moreover, to the best of the petitioner's knowledge, the royalty fixed for the said mining permit is only 140 per cubic meter. This is in sharp contrast to the mining permits and the mining contract granted through competitive bidding. Then similarly, next subparagraph, similarly, permits have also been granted in other forest areas of Gwalpara, which too were done without initiating any competitive bidding process. The petitioner has been able to obtain the environmental clearance of Sri Deepak Rava for mining of so and so. Then my lord will kindly turn to paragraph 10, my lord. Paragraph 10 at page 10. That due to the award of said sand mining permits without any competitive bidding process, significant loss is being caused to the public exchequer. At the same time, such contractors like that awarded to Sri Deepak Rava, wherein the royalty payable is significantly low, allows such persons to further sell and the sand at very low price and still earn significant profits. Now, my lord, I'll skip this, my lord. Then paragraph 19, my lord, will kindly come. Paragraph 19 is at page 22, my lord. That the respondent authorities ought to initiate appropriate legal action against all the erring of persons, including employees of the state who are overtly and covertly permitting such activities. In fact, one mining contractor, Sri Sahabul Islam, has filed a representation dated 10/12/2022 addressed to the principal chief conservator of forest brought to his notice that some issues such as grant of mining permits to Sri Typographer is an unlawful manner and the adverse impact of such practice on other scrupulous contractors and permit holders and also on the public exchequer. Mr. Sahadul Islam had cast direct aspiration of malafide of the divisional forest officer Goalpara. It may be pertinent to mention herein that this particular representation primarily contains personal grievances of Sahadul Islam, but the issue is of public interest. Now, my lord will kindly go through these two orders of the Honorable Court, my lord. That Sahadul, my lord, instituted a writ petition against grant of permit to Dipokrava. There was an interim order initially, my lord, then Dipokrava came for vacation of the interim order, and this Honorable Court vacated it, my lord. Because under Rule 5, my lord, for government contracts, permits can be issued. For example, my lord, for construction of a road, my lord, the contractor will be granted with mining permit. For that, there is no auction required. It is for infrastructural projects, my lord.
But where does it place the petitioner? How is the petitioner connected?
That is what, my lord. He has no connection, my lord. He basically espousing the cause of Sahabul Islam against Dipokrava, which Sahabul Islam tried in this writ petition. Then this writ petition stay was vacated, my lord. These are Marx phantom, my lord, basically.
My lord, may read paragraph
I'll
9.
conclude, my lord, then my line of defense can
Referring
speak, my lord.
to mining permits granted to other persons, environmental.
Others are basically, my lord,
I
to show,
am
my
not
lord.
aware of this writ petition that my learned senior friend is referring to. Your lordship, I am referring to illegal tree cutting activities in the forest.
It's
The
very,
environmental
my lord,
clearance-
faintly argued, my lord, faintly pleaded regarding tree cutting, my lord.
I have
My lord,
fact
kindly come to
photographs
paragraph
with
3
the
of this order, my lord.
GPS locations. Your lordship may kindly come to page numbers 63 onward.
More heck, my lord. Paragraph 3 of this order, my lord, will kindly see.
Yes.
This was writ petition filed by Sahadul Islam versus Dipokrava, my lord. Paragraph 3, the writ petition was instituted by two petitioners alleging that Forest Department were going to settle fresh Sen Mahal in the name of Dudno River, Sen Mahal 3A in favor of restaurant number 6, that is Dipokrava, my lord. Directly without any competitive bidding, this court, after hearing the learned counsel for the petitioner, has initially issued notice with an observation that interim order would be considered on the next day. Subsequently, when the matter had come up on so and so, the aforesaid interim order has been passed. It is not in dispute that the said interim order is an expertise 1 qua the restaurant number 6. The principal contention of the senior counsel for the applicant restaurant number 6 is that mode adopted by the department is permissible within the rules governing the field. In this regard, attention of this court has been drawn to Rule 5 of the Assam Minor Mineral Constitution 2013. This is the rule, my lord. Rule 5A, an application for grant of mining permit for quarrying of any minor mineral by the notified departments of state or central government or any of their agencies for any work project shall be made by an officer authorized by the concerned department or the competent authority. The contractor engaged for the work project of the government department agency shall be granted mining permit for the required quantity as specified in the detailed project report for execution of the work. So Dipokrava was granted the mining permit for execution of a government contract, madam. Paragraph 5, madam. The aforesaid rule is an exception carved out, which is mainly for the to facilitate government work. The rule makes it explicit that the application for grant of mining permit for quarrying of any minor mineral by the notified department of state or central government or for any work project shall be made by an authorized officer authorized by the concerned department to the competent authority. In the instant case, there is no manner of doubt that the works connected are government works which are of immense public importance. Though the interim order was passed prima facie on the said allegation of not resorting to a normal process of inviting bids. So and so, the learned counsel for the opposite party writ petitioner has also raised the number of other issues questioning the validity of the action of the respondent. He has also raised issue of competency, including who would be the competent authority under the rule vis-a-vis the nature of the project and which falls under Schedule Y. See, so and so learned counsel on the last occasion was directed to obtain instruction in this regard, and today he has placed before this court a notification dated 15/75/2013 issued by the department, whereby the divisional forest officer of the concerned division were declared to be the competent authority under the rule in respect of items under Schedule Y. See, so and so learned counsel, however, still raises the question of the requirement of approval, which according to him has not been taken. Though the other issues raised in the issue of not calling for tender would require consideration from this court. This court is of the opinion that since the interim order was passed expertly on the point of lack of publicity for calling for tenders, which has already been discussed above, and in view of the express provision of Rule 3 prescribed in rule prescribed in Rule 5, this court is of the considered opinion that ex parte order so and so, it was vacated, my lord. It was vacated on, my lord, 17/8/2022. This writ petition is still pending, making the same allegation that we have not floated tender. This PIL has been filed. Basically, to my lord, the espouse the cause of this writ petitioner, my lord, who could not defend his interim order, my lord, Sahabul Islam. So, my lord, there are situations wherein my lord has to leave the veil, my lord. Anybody coming saying I'm a social worker, espousing a cause of a contractor,
Who is the petitioner?
He is a resident of Goalpara district, your lordship. I was not aware of this.
well,
He
law
may
is
have
also
had an
settled.
individual grievance against
Where have
Sahabul
you,
Islam may have had
where
a-
have you described about yourself?
But you
Paragraph 5,
mention about Islam, but you
paragraph
mention about Rava, you mention about Islam. You know, there is somebody called Islam, somebody called Rava. That's why you mentioned the petition.
mentioned about other persons also. May
Paragraph
kindly
5,
come
madam.
to paragraph 9.
Other persons, you did not make them name, huh? Other persons.
Other persons. by
Vidya
name, your lordship.
Rajbongshi, a procurement clearance granted to be done from Damara, Samir land. See, deputy person to censor under all these permits were also granted without competitive bidding. So your idea is that this environmental clearance was wrong, fraudulently
No, your
obtained.
lordship.
You said that these permits were granted without any competitive bidding. If you say that this Goswami's department is giving forest clearance by all fraudulent means, well, maybe there may be a case for intervention of this court. Now, authorities are giving all false, fake, just to make money. There is nothing like that. It's a competitive bidding.
No,
Your grievance in para 9 is that these people, Vidya Rajbongshi, then Deep Jyoti Barua, then Jagannath Nath, all these were granted to them without any competitive bidding.
Lordship, may I read the last 4 paragraphs. These
Last.
last four paragraphs of the first part of paragraph 9
Yes,
in page number 9.
yes.
The mining in these areas is not being conducted in the assigned areas, but from the Dudhnoi River in clear violation of the respective mining permits and the environmental clearances. The next paragraph, I say one person was granted mining permit for 2 kilometers. He is mining from the river from overall area of 32 kilometers, your lordship. In clear violation of the environmental clearance granted to them, your lordship. I have annexed the environmental clearance, your lordship. There are other allegations of mining. I have annexed photographs of mining being conducted from the rivers, which is not permitted, from areas where there is no mining permits, your lordship. By persons who are conducting these mining, I do not know, your lordship, but these are illegal minings, your lordship. Then I have annexed photographs of tree felling taking place in the Goalpara forests, your lordship. The photographs of tree felling are from page 63 onwards, your lordship. These forests are being cut, the trees are being taken away from the forests, your lordship, and being sold illegally, your lord. The person who is caught illegally transporting sand is fined, but the fining is in an arbitrary manner, your lordship. Your lordship may kindly look at the fines imposed as well. They are from page 56. First, your lordship may kindly look at the illegal tree cutting activities. Page 63 onward. I've given the GPS locations also, your lordship, of the photograph. Then illegal mining activities from the rivers, your lordship, the photographs are at page 52 onwards.
Okay, you have submitted a representation to the conservative forest.
I have not, your lordship.
What is this annexure 8?
Annexure 8 was this representation was submitted
Submitted by
by
Sahabul, my lord.
Sahabul.
where he had highlighted some of these activities. Like I had averred that most of these allegations are private allegations, but he highlighted some of these activities.
My lord has seen the representation, my lord.
See, but then see the two aspects. Number one, you are saying that bidding, as far as that we are not inclined to examine that whether there was a proper bidding or not, because that individual cases are there. There may be some instance, some not bidding, arbitrary action, just because there's some we see in writ petitions, so many petitions are filed. Oh, so and so have been appointed without holding any examination. But by backdoor means, can we install PIL for that also? Suppose there is allegation that somebody has been appointed in this department without advertisement. Can we hold a PIL because of that? If there was no bidding, I mean, in some case, okay, fine, you said challenge that process. But can a PIL lie because of lack of bidding? And if there are other allegations, that the unauthorized people are cutting trees, you give more instead, you submit a representation, the authority will look into it. What do you say? You submit a detailed representation. Yes, Goalpara forest should be preserved. Correct? If there illegal cutting down of trees, felling of trees, unauthorized manner, you submit a representation, we'll see that. Because we will not open a PIL jurisdiction without adequate material. If there are material before us, certainly we will look into it.
Lordship, these photographs are, the GPS locations are there.
Okay, so let
We
it
can
be
verify
shown to
this
the because let it be shown to the authorities. If the authorities turn a blind eye saying that these are all, they may say no, what is this photograph? This is whatever it is.
Because these activities.
Yes.
These
See, what is your plea? What is your relief? Number one, competitive bidding. We are not interested in this PIL. Illegal irregular mining activities, use illegal. You inform the concerned authorities. Don't think that the higher authorities are. There may be some illegal activities by some lower officials. Once you bring it to the notice of the higher officials, maybe they will stop it. We cannot presume that just because some lower functionaries in a forest department engage in illegal activities, so we'll say the forest department is engaged in this.
Your Lordship, the averments regarding competitive bidding I have made because they're all connected, Your Lordship. All of it is being allowed by the divisional forest officer.
And Mr.
As they, Your Lordship.
Learned Counsel, how also Mr. Learned additional rulings. The present PIL has been filed seeking the following reliefs. Page 25. Thus, from the above reliefs, the aforesaid relief are sought to be substantiated by the various averment made in the PIL. However, from the above reliefs came, the petitioner is primarily seeking from the above relief sought, it appears that the petitioner is aggrieved by non-bidding while granting a mining lease. Non-competitive bidding.
Mining permits, my lord.
By non-resorting to competitive bidding while issuing mining permits to individuals. And also, allegation of illegal, irregular sand mining activities being carried out in Goalpara district. And also unlawful cutting of felling of trees in a forest area of Goalparas. As far as the first issue relating to grievance raised relating to non-resorting to competitive bidding by authorities, we are of the view that it cannot be an issue to be considered in this PIL. Coming to the other allegation that illegal irregulars sand mining as well as illegal felling of trees. We have the view that if any such activities takes such sector, the authorities must immediately put an end. However, we find from the pleadings that there are not sufficient materials to invoke our extraordinary jurisdiction of PIL to examine this issue. However, we feel it deemed appropriate that a petitioner would be at liberty to approach the appropriate authority, highlighting the illegal activities, if any, of illegal and irregular sand mining activities being carried out in Goalpara district, as well as illegal felling of trees in a forest area of Goalpara. We hope and trust that as and when such representation is submitted, the authorities will look into it so that no such illegal activities are carried out as submitted. PIL is accordingly closed.
If there is no action, your lordship, if there is no action, liberty may kindly be
It's
granted.
always there.
It's always there. Liberty is always there. Yes, next.
Ajay Nuvat,
May I please, your lordship? May I please, your lordship?
What is this, Mr. Jairul Islam? PIL for what?
Rectification of SOP passed by the Commissioner of Transport dated 26.
What is this SOP? Page
Page 21. Type
Page
of-
21.
Yes. Paragraph number 4.
Standard operating for printing of registration certificates.
By automobile dealers.
What is wrong with this?
My lord, paragraph number 4. As
Yes.
per JSR number 240E dated so and so, the records of vehicular registration is allowed to be kept in electronic form. Hence, it is not necessary to send hard copies to vehicular documents to the district transport office by the authorized automobile. Simultaneously, as registering authority, the dealers will also be responsible for verification of documents, the authenticity of information and maintenance of record. That portion, verification of documents and authenticity, it should be done by the DTO office. Other, I have no problem.
Who are you?
My lord,
Who are you?
I'm just a businessman.
What business you do?
Tailoring shop, my lord.
Tailoring shop.
Yes, my lord. Means clothes and
I
garments.
hope you are stitching the shirts and pants properly.
and
huh? You
other-
are busy in your PIL and your wrong, stitching wrong pants and shirts will have been problem. You are a shopkeeper, tailoring. Very good. See, India is a land of, see, there is a book by Mark Tully.
Well, I learned,
There is no full stop in India. It's a ever ongoing process in India. So tailors also filing PIL.
my lord.
We thought that is about that, something to do with the tailoring business. Do you own any property, any vehicle, or you are
No, I don't.
you hire taxi? Okay, or hire auto rickshaw or something like that.
I am
Who has
not-
brought to your notice this one very something?
Annexure 1, my lord.
Who has brought to your notice?
Annexure 1, paper cutting.
Paper cutting. Oh, you are a very alert citizen. Will corruption in the state decrease or crime increase? So let us try to understand, because we don't drive vehicle, we don't own. See, we are not owner of any deal. We are not dealer of vehicles. We don't know the nitty-gritty. Let us see. There was a problem at para 4 again. Simultaneously, this is your aggrieved.
Yes,
Simultaneously, as registering authority,
authority, the
the
dealers.
dealers will be responsible for the verification of documents, authenticity, information, mental record. So it should be, who is the registering authority as per that?
Dealers.
Huh?
Yeah, dealers, automobile dealers.
The dealers will be responsible for verification of documents, authenticity, and renewal. So because they're the one, they come to if I want to buy, then I'll go to a dealer, isn't it?
Yes.
So they have to verify it. So what is wrong with
Everything
that?
should be done by them, even printing and authenticity, which was done earlier by the DTOs.
Oh, you mean to say it's a burden to the dealers?
Yes, it's a burden also, and authenticity could not be proved by the dealers properly, because in a government mechanism, verification is done properly through the departments.
Dealers shall have to produce any documents pertaining to registration before any competent authority as and when called for.
Call for. When it will be
See,
called. it's
we,
not-
we are lawyers, judges, we don't understand all this car business. Can you tell us?
My
Please,
lord, may kindly have a look, page 10 for a moment, paragraph
Page 10.
17, my lord,
Page 10.
paragraph 17. What
Yeah,
is the
17.
grievance of the petitioner, my lord?
Hmm,
May I read, my lord, paragraph 17? Page 10.
yes.
That the petitioner begs to submit that due to the issuance of the SOP of the officials of the district transport offices will be drawing salaries without any work to be left to be done on their part, as the complete process of registration of vehicle will be done from the authorized automobile dealers. And this is their grievance, my lord, because nowadays
Because
there are.
everything will be digitalized, the signatures also will be digital signature. Verification will be done by the dealers, nothing will be done by the department.
Mr. Judiciary also we are going digital.
Yes.
So filing
no.
also e-filing. You will
It-
say the lawyers will not be required, then we'll.
because the court procedure.
So next day you will file in PIL, say that judiciary also going for digitization, everything will be e-filing. All these clerks in the registry, they will be sitting idle,
No, my lord.
sa khabo, nothing else.
Before filing.
All day they will be eating, drinking tea because they don't have any file to deal with. Everything will be done by this computer.
Prior to e-filing, there are many process which will be done. But here, nothing will be done by.
Oh,
the
what is
dealer.
wrong with this
Only verification procedure should be done by the department.
department?
Lordship, may I point out
A
one
similar case is pending.
section 65B of the Assam Motor Vehicle Act, my lord. This
Act.
empower the state government to make rules or regulation for the registering authority.
Is there anything, sir, let us go to the more serious side. Now, is the registering of, can this registration work done by the dealers? Dealers are the private
Yes.
individuals.
Yes.
Ms. Bora,
My lord,
registering authority,
my lord,
authority.
my lord.
Authority cannot be an pan dukan wala, obviously.
My lord.
Authority cannot be a dukandar. Registering authority. The work to be done by registering authority, can it be done by the dealer
Yes, as per
Individual.
65D, lordship,
as per rule?
we have 65 2B, my lord, of 1988 rules, my lord,
65.
my lord. 2B.
Rule, right? Rule divo.
Section, lordship.
Section 60.
65 2B.
Section 65.
Power of state government to make rules, my lord,
Yes, you can make rule.
my lord,
Correct. You are the one to make rule, but can by making that rule,
my lord.
can you delegate the authority? Can you assign the authority which is to be undertaken by an authority
Lordship.
to this businessman? He's only business shubha labh. They will see loss and profit, accounting, that book, that is more sacred than anything else. How much I earned, how much I lost. And he will try to make up the loss, increase the earning.
My lord.
That's the basic mindset of any businessman. If I'm also a business, I would do the same thing. Don't worry.
My lord.
I will try to earn more and more, more and more profit, more and more profit. Doesn't matter.
Lordship, may kindly have a look.
But can that exercise which is to be done by the state, can it be assigned to an individual, private individual? Tell us,
Lordship, may kindly have a look, the paragraph 4 again from the SOP, my lord, page 21,
page 21.
my lord. May I read,
Yes,
my lord?
yes.
Paragraph 4. As per GSR number 240E dated 31/3/2022, the records of vehicles registration is allowed to keep in electronic form. Lordship, nowadays it is electronic form, all are available in the
Yes.
website. Hence, it is not necessary to send hard copies of vehicular documents to the district transport offices by the authorized automobile dealers, because it is in the electronic form. So hard copies are not necessary to send the DTO's office. Automobile,
Simultaneously,
as registering
a
authority.
registering authority.
The
What is the definition of registering authority? Can you tell us? What is the power of a registering authority?
Lordship, as per 65,
No, we can understand dealers also keep their
my lord,
data. Okay,
My lord.
of this, who is the owner, who is the vehicle, no problem, issue. Everything they must maintain.
Lord.
But then, what is the role of a registering authority? That cannot
They
be
have to
undertaken
register
by.
the vehicle, Lordship, but by this SOP, the government has given the power to the dealer to verify all the
No,
documents.
that can be done. Then let but then ultimate there has to be another authority
This
because
is the
that.
government, Lordship. Lordship may kindly have a look. Simultaneously, as a registering authority, dealer will also be responsible for verification of documents, authenticity of information and maintenance of records. Dealers shall have to produce any documents pertaining to registration before any competent authority. Competent authority is the government, my lord.
As and when called
As
for.
in when called for, and paragraph 5 also.
See. If they don't have time, then they will not do it. In the meantime, all these dealers, there will be good dealer, not so good dealer, bad dealer, very bad dealer, worse dealer. You have all kind of people,
Lots.
good people, bad people. You don't say that all people are good. Otherwise, IPC won't be there. Okay.
My lord.
Some people are good, and therefore you go to pilgrimage. Some people are not so good for whom IPC has been made. So there may be good dealers, and what about not so good dealer and bad dealers? They do not properly maintain, they manufacture, they manipulate records. Some terrorists will come from this country, they will record and they'll bribe this dealer. Then they okay, make this old one to be a new one, and he will buy and go. And this DTOs are busy because of various reasons. They don't have time to see that, verify it. Then this vehicle is taken by this terrorist and is bomb blast during the election. Election is coming, bomb blast. Who will be responsible?
Then
So show us what is the power of this registering authority.
Sure.
That cannot be assigned to any non-government agency. Let us, what is the power of a registering authority under the Act? Can you tell us?
lordship.
Registering authority. Please tell us.
Before that, may I lordship draw the attention clause 5 also.
Clause 5, yes.
Page 22. Every dealer shall have to maintain Form 19 electronically as per Rule 43.
No, correct. They have to maintain.
They have to maintain.
If I sell, I must maintain the record who is purchasing,
My
because
lord.
then I can trace out.
My lord.
So that bomb blast in Bombay, those second hand are there, so you can trace who has sold, who has not. So that is okay.
My lord.
But what is the role of a registering authority? Mr. Why you are the petitioner? You are not selling us anything. We are trying to understand. You are the one merrily smiling away. You tell us what is the role of a registering authority. We are doing to research now.
No, my lord.
You come do
Registering-
research properly.
Registering authority.
No.
As per Rule 1998.
Yes, what is the rule?
registering authority 37, my lord.
This
Registering
one, madam.
No, lordship. Assam matter.
Act or rule?
Act
Motor
of-
Vehicle Act 1988.
1988.
My lord.
Which section?
37, my lord.
Section 37.
Registering authority means an authority empowered to register motor vehicle under chapter 4.
So section 20,
37, my lord.
section 37. Just a minute.
Lordship, may kindly have my book for a moment.
Section 37.
No, 233. Is it 237?
237, my lord.
Oh,
not 37.
237. Okay, keep it there. 237. Oh, yes, section 237. Oh, okay.
Clearly says registering authority means registering authority is defined under chapter 4.
Let us see
Yes, my
chapter
lord.
4.
Yes, it page, start from page 15, my books, my lord.
Registering authority means an authority empowered to register motor vehicle in chapter 4.
My lord.
See, let us see chapter 4.
Chapter
What are
in
the
my
duties of
is
the chapter
page
4?
50, my lord.
Can it be done by a dealer? Chapter 4. Because tomorrow, if you say the dealer also will try, regulate the traffic. Let us see chapter 4.
My lord.
Chapter 4 start from which section?
39, my lord.
39.
In my book is page 50, my lord.
Section, yes, registration. No
Registration.
person shall drive any vehicle driven when registration chapter and registration has not been suspended since. Okay.
Section 40.
Section 39. Subject to provision, every owner shall cause the vehicle to be registered by any registering authority in the state in whose jurisdiction he has residence, business where the vehicle normally kept. Registration how to be made?
Stated by the registering.
Registration by any registering authority in the state. An application, a special province for registration motive in diplomatic offices. Production of vehicle at a time registration. Refusal of registration, renewal registration, effective registration India. Certificate of registration, he can issue certificate of registration. Can the dealer issue a certificate of registration?
Page 34 of the petition, rule 48.
Rule 48.
34 of the
Rule 48.
certificate of registration.
Complete.
Or a fully motor vehicle.
Sorry?
Bottom lot, 48, rule 48 in. Page 34. Page 34 lot.
Page 34 of the petition.
Petition.
Yes?
Rule 48, bottom lot.
Rule 48. Go ahead.
Issue of certificate.
In the miscellaneous rule, issue of certificate of registration for building on submission application by a dealer for registration to with the on submission of an application by a dealer for registration.
Or owner.
By a dealer for registration of a fully new condition or by the owner of registration is being registered under the relationship. Therefore, it contemplates that the registering authority must be somebody else other than the dealer. Isn't it? In that case, how can dealer be a registering authority? Madam, please take instruction.
Sure, my lord.
We'll feel that. Tailoring master. Master Ji, we'll hear you. Please come prepared more.
Yes.
In tailoring, we say no, Master Ji, Master Ji. No? Not the school master.
Not a tailoring only. I am on the verge of buying also.
Verge of
Buying a car also. I
buying a car.
uh,
Okay.
means.
Oh, that means you are a very good tailor. No,
Cloth
very,
stores also.
very popular tailor. You have made so much of money, you will buy a car.
One submission I have to make.
No. We'll come on Monday, Tuesday. Come. We want to clarify. See, the Master Ji, he's teaching. Suddenly he wants to buy a car, and he realizes there's something serious. So let's just-
My lord,
Possibly
one-
leave the matter Friday, my lord.
Not this Friday. Come on Wednesday. Take your time. We are not admitting anything. Just we want to know also learn. See, we also learn because otherwise we won't have any idea. Because first of all, after becoming just we don't buy cars, no. Sarkar diye. So we not bother car dealer koribo. No, we don't bother about this. If it is done, they always registry people do. See, as a judge, we become more and more illiterate in many things. We rely on the protocol. We rely on the registry. We don't know what is happening. So Masterji has brought to our notice certain thing. We'll see.
Lordship.
Just see that registering authority, can it be assigned to a dealer who is an individual, who is a businessman, whose prime motive is to not only make this country strong and vibrant, but also to make money for himself. And if he has excess money, he can donate to some people. If he wants. If he doesn't want, he will not donate. He will keep for himself. Okay?
I'll get instruction, but at
Yes.
65B, the government is empowered to.
We can't empower to anybody, Mr. Madam.
Okay.
You can't authorize, okay, some lawyer is sitting idle. Okay, we'll appoint you as an authority. Can you do that?
First, I'll get the instruction. my
The
lord.
authority is very important, registering authority.
Okay.
You can't give it to somebody saying, oh, you are sitting. Boy, I say, I will make you an authority. See, there must be some criteria, some principle for making a person an authority under a statute.
Lordship.
And whether the dealer can be made a registering authority. Important question of law.
Lordship.
Master Ji, you also come prepared on that issue
Lordship may fix the matter on Wednesday.
Wednesday.
My lord. Deeply obliged.
List on Wednesday.
15 February. Item number 3.
Yes, yes, Manoj Karane, Karnani.
This is another simple case, my lord.
What simple case?
My questions are very simple. He is a tenant, my lord. So the property of the landlord was supposed to have been sold off by way of auction sale pursuant to a SARFAESI proceeding. Now, my lord, bank is pressurizing him to vacate the premises.
So what is the right of a tenant?
It is there, my lord, under the 16 amendments under the.
Where is that word?
SARFAESI, Monica,
SARFAESI Act. SARFAESI Act,
under section 17, my lord.
17. Are you a genuine tenant or they're put up by the landlord?
My lord, that has to be
And that-
ascertained by a court, competent court, that is DRT.
Oh, but you must show some prima facie
I have
document to
those-
say that
I
you are a tenant.
I have-
Otherwise, whenever there is an, the landlord will
have
find a
those.
tenant. Aha,
My lord,
then
I
you
have
get
it.
this, then section
17, my lord.
7717.
17. Tenant to rent. Yeah,
17.4.
4A.
Yes.
Any person in application.
If
under
the
subsection.
section 17.4.
Yes, my
17.4 is if the debt recovery tribunal declares. This one? No, which one you are reading?
SARFAESI.
2002 SARFAESI Act. Yes.
Mm. 17.4, my lord, there's any person.
Section
17.4A.
4 capital A.
Yes, my lord.
Okay, where any person in an application under section claims any tenancy or lease rights upon the secured asset. The debt TTR after exam facts of the case evidence shall for the purpose of have the jurisdiction examine whether lease or tenancy expired or stood in contrary is created up to issue default. If they satisfy the tenancy lease claim in so, then contrary so may pass other items in accordance with the provisions of the act. What order can be passed?
Now, my lord, I had a right. to
Suppose
file
is the
appeal.
fine, huh?
I had a right to file appeal, my lord, under the provisions. But what has happened, my lord, there is my lord, a stipulation of time, 45 days. And SARFAESI Act do not contemplate any condonation of delay. Therefore, the applications after the limitation is not accepted by the tribunal. Here, the tenant is facing this problem that he was not served with a notice. He didn't have knowledge. Now he has been pressurized to vacate the premises. He says that I want to challenge this, the notice.
Okay. Yes, madam.
Only if delay is condoned, if I go. there,
Madam, yes, you are further.
Means for the Indian Bank, all respondents, the account was declared on 1st of May 2021.
Correct, but you didn't know that there is a tenant who is hiding there in his property. You didn't bother to find out.
And secondly, they have not produced any tenancy registered agreement to us.
It is not registered, of course.
You require
I mean,
registration
yes,
for tenancy.
yes.
Is it law? Suppose if he is
Generally-
not a registered tenancy, it will be month-to-month tenancy perhaps.
Generally, they do 11
Can you
months.
think that the
agreement.
month-to-month tenancy is not valid?
Month to month means generally they do 11 months. agreement.
Correct, that is what.
Yeah, yeah.
That is what they don't, because they don't want to register. And that is not illegal. Is it illegal to be a tenant without being registered?
So we have to see whether it has been continued from the date or.
So that is why you see that. You see that.
And no copy has been served upon us and neither
Madam,
did the
what-
agreement copy also.
Huh?
During the course of the day.
You are doing same thing like the DRT, without serving copy. You want
There
to
was no
have,
standing counsel. They are not standing counsels in the High Court there.
or they are not.
I'll serve.
Can you serve a copy?
My lord, please.
Okay. And Ms. Chakraborty Lane counsel for the thing. The plea of the petitioner is that he is a tenant of one what?
My lord,
He is a tenant of
respond number 5.
Respondent number 5, against whom a proceeding has been already initiated under the
SARFAESI.
SARFAESI Act, under which the authorities are seeking to possess the said property, in which event said property, and asking the petitioner to vacate the tenant
Lease out property.
the leasehold property. It is submitted that tenant is protected under section 17.4A. And without exhausting the said procedure mentioned under section 17(4) capital A, the petition could not be liable to be evicted. Okay. The matter will be examined. Let you take, you are appearing for
Indian Bank,
Ms.
S Chakraborty.
S. Chakraborty appearing from Indian Bank, seek some time to take instruction. This after 2 weeks.
And
Copy of this petition may be furnished to Ms. Chakraborty. You are Chakraborty.
Yes, Chakraborty.
You are also Chakraborty. Chakraborty versus Chakraborty. Okay.
Till then, my lord, the status quo over the
Okay,
property.
till then, status quo as regards the possession of the property by petitioner may be maintained. Next,
Short date kindly be given, my lord,
2
because
weeks. Nothing will happen in 2 weeks. You take instruction. Director Dido.
24th February.
highly obliged.
Item number 4.
Nazir, what happened to you, Nazir?
My lord, the issue is that, my lord, whether they were a secured creditor, my lord, take possession.
You are
of-
a secured creditor.
I am not secured creditor. My question is whether the secured creditor can take the possession of the borrower's land other than the, my lord, place property to secure the loan of the, my lord, principal borrower, my lord.
Who are you?
I am the, my lord, guarantor of the.
Yes, madam, you want to say something?
May I please, your lordship, I am for the Union Bank.
Yes, what do you want?
Copy have not been served.
Yes, my lord, there is no standing council, so that was not.
Okay, now that you have got a stand.
So I can, my lord, if it lordship issue the notice, my lord, I'll serve the notice and, my lord, by this time, my lord, the no coercive action should be taken.
Okay, her Mr. Lanagan. Her also Miss
S. Yasmin.
Yasmin,
Yes.
other Union Bank, who prays for taking, allowing to take some instruction, to take time for taking instruction, prays at least after 2 weeks. In the meantime, status quo as on today be maintained as regards the property.
Must-
The copy of the petition may be furnished to Ms. Yasmin. Yes, yes.
Much obliged.
Item number 5.
What is this Geetartha Sharma? What happened to you, Geetartha?
Petition of your lordship is the had available loan lordship and
How much?
loan of rupees lordship 46 lakhs lordship.
56 lakh.
Yes,
How much you have paid?
Lordship, initially the EMIs have been he is paying the EMIs regularly lordship. Thereafter he have failed to pay the
How much you have paid? Total
Lordship,
so far?
Lordship, subsequent lordship has page 27 lordship. One compromise offer of settlement was done between bank and the borrower. And
Page
27 lordship. Sorry.
27. Then
Then lordship, he has paid an amount of rupees 8 lakhs 50,000 lordship. His bank statement is there lordship.
this compromise settlement in September 2022.
Yes.
Then
yes,
what
lordship.
happened?
Then lordship, in the month of November lordship, he had failed to pay lordship because of his father's ailment lordship, and he has also intimated the bank regarding that lordship. Subsequently, at page 32 lordship, the bank has issued the failed compromise letter lordship,
So
and subsequently he approached the bank to pay his some amount, but the bank is not accepting his amount. However, there are certain oral conversation between the bank and the petitioner that bank will grant him time.
who is the bank? Have you
State-
served notice on the bank?
State Bank of
There
India.
is no standing counsel
No,
of the
no,
bank.
lordship. And lordship, on 2nd of February, lordship, the one recovery agent has called him and told him that his mortgage property will be asking to hand over the keys of his mortgage property to him, because bank will take the possession as this compromise has been failed.
Bank can directly take possession.
Lordship, the possession notice was earlier issued in 25/1/2022 before this compromise letter lordship, and thereafter now no compromise letter has been issued.
So if you are not paid, bank will come and lock your room. How?
Lordship, possession, that was lordship symbolic possession notice lordship.
Symbolic or no symbolic,
Yes,
can they do that? We don't know.
Yes, as per my understanding, lordship, one
You are saying all these things because the counsel for the bank is not present. You give a copy
Lordship.
and we'll see whether you sing the same song on the next week.
Lordship,
Okay.
there is no standing council, Lordship.
Oh, you furnish a copy.
By-
Okay, hard Mr.
SN Krishna Trail, Lordship.
Krishna Trail, Lari
I think
Council.
Mr. Nondi used to appear earlier, I'm not sure.
No bank, SBI people here. No lawyer, counsel who normally appears for bank. Manager may have a different idea, but then we can also ask Mr. any counsel. No, SBI, they have a large pool of law.
Yes, Lordship. There is MPLN advocates are there, Lordship, but
They don't, can't you see any fine face here, MPNL lawyer of the bank?
no, Lordship. I personally don't know, Lordship.
Okay.
My lord, I think senior advocate, my lord, SS Sharma is there. my lord.
Is he here, Mr. Sharma? For the bank? SBI,
Is there, my lord.
largest bank in India perhaps, huh? Yes, anybody for bank? Anybody know? We want the bank to,
Yes,
have an idea from bank what is happening
Yes, Lordship.
and how much you are willing to pay also.
Lordship, at present, Lordship, I am ready to pay 5 lakhs, Lordship, by
5
today
lakhs.
itself also,
Today
Lordship.
itself.
But Lordship, the problem is the bank is not accepting my amount, Lordship.
Oh, bank is not accepting.
Yes, Lordship, that's
Very-
why I could not.
There is also reason why we want to know this bank, why they are not wanting the bank. 5
Lordship,
lakhs
if-
somebody offers, everybody will take, but why
Yes,
the bank is not taking?
Lordship, in that case, Lordship, I may be allowed to take dusty service upon the branch, Lordship,
Okay, take
By-
justice service.
by.
Okay, hard Mr. Dada, who may serve notice upon the bank by way of dusty. As you would like to hear the bank. Place the matter again on next, after 1 week or
After 1 week.
Huh? Tuesday, Monday, Wednesday, the next.
Any day, Lordship.
Okay,
Lordship.
at the try di দিব.
18 February.
Huh?
Lordship,
In the meantime, no coercive action be taken against the petitioner by the
deeply
bank.
obliged. Lordship.
For admission, item number 6.
Item number 6. Yes, what is this state of Assam 2018 all appeal? Yes, Mr.
Yes, Madam. In earlier 2 occasions, Mr. R. Mozumdar appeared in the matter, Madam.
R. Mozumdar. Then what happened to him?
Took time also, Madam. But
Took time for what? What is so?
Obtain instructions.
What is the why you have filed this appeal? Why you are so aggrieved by this order? What is so wrong with this order?
Madam, today, Madam, I don't.
In
have
view
a
of the matter, rejection of Canadian petitioner considered to be wholly inequitable, therefore, been disposed diagnosement to consider appointment in the Azhar High School, to consider. To consider appointment in any rejection. However, though had prayed the annual granted, consider is consider. Consider means the court did not direct appointment. Consider. And you say after putting your microscope, you find this virus, this bacteria. So we can't. He is sick. Say that. Yes, what to do? Tell us. Where is Mr. R. Mozumdar?
Now, at present, he's on leg, Madam. He's not available, Madam.
Okay, ask him to come when he is free.
Yes, Madam.
Yes, next 2018 matter. There is no point now. 5 years. What will you do?
Yes, Madam.
And what is you are for whom?
I'm for the petitioner, my lord.
Where is he or she? Zarina is she?
Yes, my lord.
Where is she now?
In the said school, my lord, she is working in the contextual basis, my lord. She's
And
in
you want appointment to the post of?
regular post after due selection process.
Yeah. And why it was the High Court? What is wrong with the High
She
Court?
was selected, my lord, but she was not appointed on the ground that, my lord, overage.
Overage.
She was overage,
By
but
how many years?
her age was condoned, my lord, up to 45, and she is within 45, my lord. So, my lord, this one.
Her age was condoned earlier.
Yes, my lord.
Occasion, but not for this particular selection.
Department saying that.
Her age was condoned earlier. Now for this selection.
Department condoned up to 45 years, and I am within 45 years.
Once you are condoned.
Yes, my lord.
Mr.
And
Mr.
in
Please,
paragraph
please
20
call Mr. Majumdar.
In paragraph 20,
And-
my lord,
And the more this case will pending, she will become old and old, and by the time she will be 60 years, then you say, no, my lord, she's 60 years, she can't be appointed. 2018 matter.
Yes, my lord.
Either you take it or we dismiss it. We can't keep this matter pending.
Yes, my lord.
5 years now. By this time, she will be how many years now?
now
50 years.
50 years.
Another 5 years, 55. So you wait for another 10 years, she will be 60. Then you say, my lord, she can't be appointed 60 years.
My lord, we fix
Sorry,
on
sorry.
Friday, my lord. I'll.
So
No,
this,
let him down.
Kolina, this cannot go on. This cannot go on. Once you have condoned, I mean, she's fit to be 45, then why you take this technical
And
plea?
in paragraph 20, my lord, everything has been discussed, my lord.
Please call Majumdar. Yes, we'll
Okay.
wait for Majumdar. Yes, next.
Item 7.
Rajesh Sinha. Yes, what is this?
Your lordships passed an order on 19th of January. Directing the exercise as directed by the Honorable Single Judge be carried out, but that order has already been passed earlier. So, my lord, I have filed a representation. saying that-
Exercises by direction issued and Shingajas may be undertaken, however, will not be implemented. So what is to be done today?
Now, my lord, I am praying for a stay because the fact that, my lord, the service of the petitioner was provincialized in 2013. And that provincialization order was challenged by the the respondent number 1 herein. And this honorable court directed that the matter be referred to the district level redressal committee. The district level redressal committee gave a report that although my service has been provincialized, my name does not appear in the DIAS data of 2009 and 10. So on the basis of that report, my provincialization order was cancelled. Then I challenged this order, and this honorable single judge has held that this order cannot stand. But thereafter, certain my lord, directions have
So
taken.
where are you? What is your status now? Are you
No,
a provincialized or non-provincialized now?
Provincialization order was there, that was challenged by the private respondent. Thereafter, my lord, my provincialization order has been cancelled.
Cancelled.
And the honorable single judge, when this cancellation order was challenged, the honorable single judge held that this order cannot stand.
Then that means where do you stand
In
now?
spite of that, my lord.
Where do you stand now?
Now, my lord, I have been not allowed to work in the school.
The school.
And then private respondent, I mean, the respondent number 1 is nowhere in the picture, my lord. The post is there, I can be at least till the.
Who are
matter is
you?
decided.
My lord, I am senior, my lord, then the appellant, my lord.
Huh?
I am senior, my lord, teacher in the school.
Oh,
my
you also want to be provincialized. Oh,
my
there is
service-
another contender.
My service also
My
has
lord,
been, my lord.
my
I am
services
senior.
were provincialized under the 2011 Act.
And who challenge
2013.
your
My
provincialization?
lord, she's challenged it.
She wants to be a
She
provincialized.
wants to be provincialized. That cannot be done now.
Why?
my lord.
Why can't be done?
Because my lord, 2011 Act is no longer there. my lord.
Not there. But if the authorities had correctly done, she said, I should have been provincialized, not you. So we have to go back to that stage.
Yes,
You
my
can't
lord, but
today,
the fact remains that the respondent number 1 is not serving in the school at all.
So what is to be done today? Please tell us.
Your lordship, I have kindly stay the order of the
Stay
honorable single
of
judge.
the.
Of the order of the honorable single judge, and let me work in that school, my lord. Let me serve till the matter is finally heard.
Somebody has to continue. You are also not provincialized.
My
It is
lord,
not provincial.
So,
my lord.
are you also teaching in the school?
Yes, my lord.
Very good.
Yes, my lord.
She is not listening.
But you are not, you are teaching, but you are not teaching not as a provincialized teacher,
Not a.
normal teacher.
My,
And she was, he or she,
He, man.
and he was provincialized. Now that provincialization was challenged by you. Now, according to him, he is not allowed to work as a provincialized teacher. Somebody has to continue, no, either you or A or B.
So there are two posts, my lord.
My
Huh?
There are two posts.
So let him continue provisionally.
my lord.
Provisionally provincialized.
My lord, I am.
Her provincialization is provisional, will be subject to the writ appeal. If she succeeds, then she continues the province. If she doesn't succeed, she goes back home.
Right.
At least some students will get some benefit because she will be surcharged with this benefit of provincialization. She can devote more attention. Not provincialized, she will come dressing from home. What is the point? Because if you can continue as provincialized, one can understand. But your provincialization has to be processed. His provincialization has been already processed, but somehow you challenge it and you say you cannot. Okay, Mr.
Kindly see.
We'll hear it is purely temporary nature, nothing.
22 only kindly.
How does it help you?
Yes,
Suppose we pass a stay order now, how does it help you? How does it damage your case?
My lord, paragraph 22 of the judgment, my lord.
Paragraph 22 of the judgment.
Yes, my lord. Running page 282.
282.
Yes.
Yes, 282.
Paragraph 22.
Yes. In view of the director passed necessary cancelling permission and after that is why he wants to stay. No problem, we'll examine. Correct. Therefore, we say that if she is not successful, she'll be out. If he is not successful.
In the same page, if you also reads my paragraph, the first paragraph in that.
Okay,
same page-
Mr. Lanes in accounts.
In the first paragraph, the honorable single judge says, my lord, the order cannot stand.
Two posts are there. Two posts are there.
That is what. Yes. No, in fact, my lord, your lordship, my learned friend is referring to paragraph 22. In the same page, in the first paragraph, the court has held that my order of cancellation of provincial cannot stand. That is the last sentence of the first paragraph, page 282. As such, the said order dated 16/8/2016, being not in accordance with law, the same cannot sustain. So thereafter, my lord, my grievance is that after holding this paragraph 22 directions are contrary to the finding.
What is the direction?
Direction is that in view of the above, director of education is directed to pass necessary order cancelling the provisional service of the petitioner. After obtaining necessary approval of the state government in the elementary education department. And that is also under 2017 Act. My provincial is under 2011 Act.
Okay, her Mr. Lanes in counsel for the her also Mr.
Yes, Your
Counsel, respondent number
1.
Mr. Khotonia.
Secondary education department. For secondary education department.
This one. The matter will be of the view that the matter can be heard finally and later may be listed for hearing in usual course. However, in the meantime, the impugn order dated 2/4/2019 directing cancellation of the provincialization of the service of petitioner will remain stayed.
And he'll
In which event he will be allowed to continue as a provincialized teacher in the school. Which school?
My lord,
Tarbin Chera.
any school.
Where is this Tarbin Chera?
That is Karimganj district.
Tarbin Chera. Is it near Cherapunji?
No, the Karimganj. Some cool air goes perhaps there.
Tarbin Chera, ME school. However, this is purely provisional in nature and will be subject to result of this final result of this.
My lord is there. This my lord.
However, this also will not come in the way if the state government also considers the case of the respondent number 1 for provincialization, as it is mentioned in the order that there are 2 posts vacant, 2 posts of teachers vacant in the said school.
But my lord, this order already implemented because my lord authority cancel his appointment.
Yes, next.
Item number 8.
Puba Julaguti. Jaluguti.
May I please look at?
Jaluguti.
The NIT lordship issued by the Deputy Commissioner Nogao lordship. The settlement of-
Jaluguti in Tamil Nadu is called Jalakatti. Different, no? Not Jalaguti in
the settlement of number 4.
What yes, yes.
Part 2 was settled with the appellant lordship. By order dated 24/8/2017.
So today is to be done what? After so many days?
Lordship, we have also
Adjourned. P. Bhuya. Lanika respond having obtained considered the adjourned. Then DK Das, respondent number 1, adjourned.
we have not.
Then next is appellant Sharma. You are Sharma. Her also DK Das. Mr. Sharma shall furnish copy relevant document Das. You have furnished?
Yes, Lord, we have finished.
So what is to be done today? Tell us. I also for.
I also lordship, we have.
I was not listed.
Sorry?
I was not listed, madam.
I was not.
They have filed the IA.
Huh.
That was not listed.
It is here today.
He's here today.
Yes, Lordship.
IA for what?
Lordship, we have annexed some documents, Lordship, that was not. Yes,
IA for some relying on some documents. Okay, what is to be done today?
Lordship, what happened?
Only IA, my lord, I have to file affidavit, my lord.
Oh, fine, no
Yes,
problem. But what is this writ appeal about?
Lordship, we have the Learned Single Judge have interfered with our settlement order, Lordship, on the ground that
Your settlement for what?
Lordship,
Fishery.
number 4, Sunai Nodi Part 2 fishery. Lordship.
Fishery.
Yes, Lordship.
Then it was set aside by
that
the,
was issued on 24/8/2017, and
on what ground it was set aside?
Lordship, the second highest bidder and fourth highest bidder whose bid was cancelled by the authorities, and that was held to be arbitrarily cancelled, and accordingly the.
Now, who is running the fishery now?
I am, my lord.
You are running the fishery. Who are you?
I am the mother, high bidder.
Huh?
I am the high bidder.
But he is the defaulter, Lordship.
Okay, then we'll examine. Somebody is fishing. Next time you fish, what is there?
Let me make grant short
Huh?
time.
Okay, hi, Mr. Lane Council for the appeal, also Mr. Lane Council for the respondent number
1.
one, also Ms. What is that you are appealing?
Yes, Lordship.
For the state respondents, huh?
Yes, Lordship.
The matter may be heard. List for hearing in usual course. Yes, next.
Right.
Lordship may fix it.
No, I mean, it was
7 years settlement period, Lordship. And from 2017 of stay running, Lordship, and thereafter.
From 17 to 20,
22
you have
January.
been running. So you have caught lot of fish. Let him catch some fish for some time. What is there?
So after March, Lordship,
You all, only you want to catch the fish.
last part of February, Lordship.
If I stay, then who will run the fish? And
No,
then
I have paid him, case money, everything, my lord. I am.
I said, if we stay this order, doesn't mean that you can catch the fish, then the fish will roam around, they will be happy.
Lordship, peace
Not
loving
you.
state, peace loving state,
Ah.
Lordship, therefore.
No, we are
Therefore,
also-
somebody has to catch the fish. Who will catch the fish if we stay the order? Then fish will have a free time. Fish will have a very nice time. Huh? No one is to catch
If
it.
Lordship allow us to.
No, sorry. Somebody should catch fish because BU is coming. He will catch the fish, let him catch. Next, yes. Other Raman, yes.
Item 9.
9. Shekhar Datta. Yes, what is this?
Your Lordship,
Yes, yes.
Matter pertains to acquisition of land and non-payment of compensation, Lordship. Respondent.
Government has acquired and not paying you.
And subsequently it was withdrawn also, but the compensation was not paid to the villagers.
What has been withdrawn? The acquisition has been withdrawn.
Acquisition,
So you go back
notification
there,
was
then you go back.
Lordship,
You don't want to go back there.
no, possession was not taken over, but.
Then you are still there.
Still there, but the
Then
thing is that the withdrawal notification was issued under section 48.
whatever it is, they say we don't want this land.
Yes,
So there is
Lordship.
no compensation for the full damage on the land.
Or damage. They cause some damage to your land. What kind of damage?
Land was for more than 2 years, it was under the possession of the government, though they did not take over possession, but the
They did not
villagers,
allow at all.
the village.
What is this, mister? You don't allow, then you say we don't want this land.
No, the finding of the honorable single judge is
Huh?
that they have alleged that the possession was taken.
Yes,
And the finding is that possession was not taken.
was not taken. But they themselves did not go.
No,
Then
it's a vacant land.
vacant land. That land belongs to, what is in the land? Grass, house, what,
Trees were there,
tree?
hatchet,
Huh?
trees were there, Lordship.
Trees were
hatchet
there.
were
Huh? Trees were there and the
hatchet,
Huh?
some huts were there, Lordship.
huts were there.
Yes, Lordship.
You want compensation for that.
Compensation for that,
For-
because they were under bona fide belief that since the land was acquired by the
You-
government, so
See,
they.
you file a civil suit. That will be the best. If you think that because of this act, we are not allowed to enter, therefore we could not eat the mango which was grown.
Yes,
We
Lordship.
could not eat the guava which was grown. We could not catch the fish in the pond. So damage was caused to us. You file a civil suit. That will be better.
Lordship, here respondent number 4 and 5 have filed their affidavit in opposition, and we had received one copy, and we.
Who is 4 and 5? Who is 4 and 5?
Deputy
Deputy.
Commissioner. Lordship.
What did the deputy commissioner supports your case or what? Then
Now their contention is that they want to withdraw that withdrawal notification, Lordship.
let them withdraw, let them, if any damage has been done, you can file appropriate forum, you prove, you go and tell the government also. But before you go to the civil suit, you apply that this is the damage you have done.
Lordship,
Government may,
Before approaching this honorable court, representation were filed before the concerned authority, but they didn't give any response.
okay, you respond to that. You respond to
Lordship,
that.
we want to file the
That
reply
direction is
to
there
that
only.
Huh?
affidavit in
That
opposition.
action is there by the Honorable
You do it then. You do it. If you see if they have if they have been deprived of the right, you have a duty bound to do it.
As a matter of fact, madam, after the
Lordship, kindly some time may be
What
granted
time?
to file the reply to the affidavit. in
No,
opposition.
we are not accepting their affidavit also. We will not even look at their affidavit. We'll just go for we'll direct them, if any damage is done, you.
The direction is
That's all.
already there,
Yes, page number.
last page. Accordingly, this petition is disposed of with the direction of the petitioner to raise his entitlement before the appropriate forum is in.
You forum, you do that. Yes.
In fact, my lord, in course of deliberation, one,
So you are final, no withdrawal. Don't say again, we want this land again.
no, my.
Don't do this, ping pong.
My
Huh?
lord,
You are not required
my lord,
this.
we are not the requiring authority. Requiring authority is the army authority.
So they have not required, no?
Immediately thereafter, they informed that we do not require the land because of the nature of the land. It's very low
Okay.
lying.
Okay, very well.
Soon thereafter, it was, when
There was some communication earlier about,
there were some communication.
Ah.
In fact, if your lordship recalls, my lord, there was some deliberation before court number 1 and the matter was taken up.
no,
What has
where
happened
is
is-
that communication?
My lord, I'm just coming to the lordship, give me just 1 minute. The background is this. After the preliminary notification under the old act of section 4 was given, nothing was done. And in such a circumstances, pursuant to the instruction by the army authorities that we do not require in land, the preliminary notification itself ought to have been withdrawn. But unfortunately, my lord, there was some confusion. File noting also I have collected. The decision was in the file noting to withdraw the notification itself. But unfortunately, the withdrawal was done in terms of section 48(1) of the Land Acquisition Act, old act. So section 48(1), if withdrawal is made under section 48(1), then the determination has to be there under section 48(2). But if possession is not taken under section 16, the very withdrawal of the notification itself will suffice. This is what the Supreme Court says, man. So then this one put director that we file an affidavit. That is how we file the affidavit, man.
See, the question is that we are not going to, see, if you want to enter again, then then whole
No, no,
thing
no.
nature, no?
They
So
are
once
filing
you
the
want to,
army
they are not
authority.
interested in this land, the matter ends there.
My lord, army
Later on, if the government of India says we want, then it's okay. That's a different issue. Right now, as on today,
this issue is not coming at all. Army authority has already indicated that we do not want the land.
see, madam, there is no point keeping this.
Lordship,
You are
but
causing road blockade. Number of vehicle in our judicial traffic is increased because of this kind of punctured vehicles lying on the road. We want to clear this.
Where in the affidavit have you stated that it was wrongly issued?
Yes, ma'am. Lordship, can you see the affidavit? I think is it on record, ma'am? Affidavit, I'm told that. Paragraph 6, I have indicated.
If your affidavit in the position,
It's an affidavit, additional affidavit, ma'am.
additional affidavit,
My lord. I'll just read paragraph 5
Affidavit.
and 6, ma'am. Lordship will kindly permit me.
There
There in the instant case,
additional or affidavit in opposition?
it is.
We have an affidavit in opposition.
affidavit in opposition, Lord.
It was filed yesterday, actually. It's not on
Oh.
record. Because
there you have clarified that we don't require this.
no, it's not our clarification, it's the army authorities.
Army
clarification. We are here clarifying only one thing, that the notification of our withdrawal ought to have been a simple withdrawal of notification in terms of section 21 of the General Clauses Act, my lord. Instead of 48(1), and we seek a liberty rather to issue an appropriate notification. Lordship, may kindly see paragraph 5 and 6. That in the instant case after the publication of preliminary notification under section 4 of the Act, no further steps under section 4(2) or any other provisions of the Act, including steps under section 9 of the Act, were taken. As a result, no officer was appointed to enter upon the land and cause damage to the land, building, dwelling house, etc. As stated in the earlier affidavit of opposition, no possession of the land was taken from the Pattada interested persons. Because after publication of the preliminary notification, the Indian Army informed that the land was not required by them. That since no notice under section 9(1) of the Act was issued, the
question of withdrawing from acquisition under section 48(1) did not arise. This will be evident also from the fact that, as stated above, after the Indian Army informed the collector Kachar Silchar that they have no requirement of the land in question by letter dated 8/11/2010, the respondents decided to withdraw the notification under section 4(1) itself. But due to misconception of the law, the authority proceeded as per section 48(1) of the Act. It is pertinent to mention herein that confusion might have arisen because of the language of paragraph 100 of Assam Land Acquisition Manual issued by the Director of Acquisition and Reforms. The judgment of the Honorable Supreme Court in the state of Madhya Pradesh versus Vishnu Prasad Sharma, reported in AIR 66 Supreme Court 1593, as well as judgment of the Honorable Gujarat High Court in CC Gandhi versus so and so, clearly held that unless notice under section 9 of the Act is issued, withdrawal from acquisition under section 48(1) is not necessary, and all that the government has to do is to pay for the damage caused as provided in section 5. But in the instant case, after issuing a preliminary notification under section 4 of the Act, no officer or his servants or workmen entered upon this for survey or to take levels or to do any other act under subsection 2 of section 4 of the Act. As a result, the writ petitioners and the patadars, interested persons, are not entitled to any payment as contained under section 5 of the Act. The writ petition appeal is therefore liable to be dismissed. This is the position, madam. Lordship, may kindly have a look at the judgment of 66 Supreme Court. Otherwise, my lord, this will involve
Okay, this we have filed only today or what?
yesterday. madam.
Oh, yesterday. And you have not given, you have just got
We
it
have
today.
received the copy and we
Okay.
want to file the reply to this.
Okay, then you file then.
3 weeks time may be granted.
Why 3 weeks time?
You have to just respond to this paragraph.
Was it done 2 weeks?
Yes.
Monday. You come back on Monday.
Monday.
Monday, madam.
Lots.
See, you say that you have not entered.
Right.
They say that you didn't allow them to enter, some damage have been caused. So that after all, then it comes to a realm of dispute question of fact.
This is what has been held by the Honorable Supreme Court.
Now, if they at all damage, so you undertake a survey whether there was a examine. After all,
Madam,
they are
that
all
was-
people,
madam, that
the
was-
citizens of this country,
That was
not
examined.
foreigners coming from Bangladesh and asking.
Madam, by
You ask, what is the problem?
Madam, we have disposed of their representation by speaking order, saying that we have not taken any position, no damage was caused. That speaking order also, if they challenge that speaking order, that the petition was dismissed.
Where is that army communication saying that they
Yes.
don't require?
Yes.
Where is
This is
it?
an
Where is it?
admitted fact. This is an admitted fact. ma'am.
Where is it?
Madam,
And when did they tell you? When the army told
immediately
you?
thereafter, and we also.
Immediately means you issued a notification section 4,
On 8/4/2009,
8/4/2009,
yes,
and army said that they don't want when?
on 30th of September 2010.
2010,
Right.
after more than year.
Yes.
Is it available here on?
See, more than 1 year, so these people say, oh, Assam armies are taking over, so we can't see, they respect Indian army, so they don't even enter.
No, madam, after section 4, after section 4, if there is a requirement of the land, under section 4 of the Act, an officer will be appointed to make a survey. This step was also not taken. Nothing was done.
Show us the record, show us the records. You should produce the record. We could have, because the records will speak for themselves.
Record. Yes.
Because they will speak for themselves. Because if you have not undertaken any process for assessment,
My lord.
then it was not done.
My lord,
Produce the land records.
I'm showing at least last time
LA,
records were there.
LA records, don't produce all
No,
this.
they're LA.
Is it LA record?
My lord, file noting will lordship will make it very clear. I have highlighted also.
Since you have started from the time we said army do not require, but during that period from 8/4/2009 to 13/9/2010,
Yes,
what was that?
during that period, my lord, this is what we have said in the recent.
Oh, that the record must be there. We want that. After this, okay. They don't want, then obviously nothing would happen. Because after Section 4 notification was issued,
My lord,
did you undertake enter? You have right to enter, isn't it?
we have right.
Yeah.
But
Now
we
they
have
say you have entered. According to them, maybe right, wrong, we are not saying
My
that.
lord, first we.
That the moment you issue Section 4 notification,
Lord.
you have a right to enter and
No,
also.
no, we don't have, we have to first appoint an officer for entering.
Uh-huh.
We did not appoint that
Oh,
officer.
that is what we want in the file. That is what we want. What transferred, it is an issue also. The issue before us is what transferred before that. We only said it was not wanted.
My lord, they have taken only one step. My lord, it is not their case in the repetition that some damage was caused. What they have said is, you have taken possession. That was their only contention, nothing else. And thereafter, this on the court.
In the repetition,
My lord, lordship, yes. Start from page 19.
see, they say para 3.
My lord.
Of their petition.
Petition.
However, pursuant to the acquisition, the land was taken to possession by the government and survey work started to be conducted upon land. Be it mentioned is the land was surveyed several times, sometimes by the revenue settlement, Silchar, for the public preparation, Jirath, and some other Indian Army. They keep coming. Mister, how do you say that Indian Army doesn't require unless you survey?
My lord.
You came there, you found, oh, this is not fit. Therefore, you have entered. Therefore, they were prevented. Otherwise, they would have used it by cattle, cow, all this
My lord,
for grazing also. You are not allowed because Indian Army.
My lordship may see our reply.
Para
Page-
3.
Page 57. Para 2, 3 are all replied.
Page 57.
57. Para 3 onward. That with regard to statement made in paragraph 2 of the writ petition, the respondent begs to state that notification under section 4(1) in the allocation was approved and published in the Assam Gazette of Spencer with an intention to acquire the land. But the land in question has neither required nor possession of the land taken over from the Patadar interested persons. That as regards the statement made in para 3 of the writ petition, the respondent begs to state that possession of the land has not been taken over by the collector, Kachar, and the Patadars interested persons are still enjoying their right and title over the land. That with regard to statement made in paragraph 4.
See, one thing is that if you read section 5 of the LA Act,
My bad.
the officers so authorized shall, at the time of such entry, pay or tender payment for
Yes.
all necessary damage to be done as aforesaid, and in case of dispute is the sufficiency of the amount so paid or tendered, he shall at once refer the dispute to the decision of the collector.
Right.
What it section 5 NB says is that
Right.
at a time of entry,
Well,
uh,
there is no dispute about the proposition of law that if after issuing of preliminary notification,
yes,
an officer is appointed, he enters upon the land, he causes some damage. Then under section 5, then damage has to be paid.
correct.
And there are two things. Here we issued the notification under section 48. If your lordship goes to section 48 once time.
Yes,
48 says completion of acquisition not compulsory, but compensation to be awarded when not complete.
yes,
Except in case provided for in section 36, the government shall be at liberty to withdraw from acquisition of any land of which possession has not been taken. Whenever the government withdraws from any such acquisition, the collector shall determine the amount of compensation due for the damage suffered by the owner in consequence of the notice or of any proceedings thereunder, and shall pay such amount to the person interested, together with all costs reasonably incurred by him in prosecution of the proceedings under this act relating to the said act. So
Hmm.
there are two types of compensation. One, which your lordship is indicated under section 5. Immediately after section 4, if some survey is made by an officer, if damage is caused, then compensation under section 5. But if the land acquisition proceeding continues, award is passed, but possession is not taken, then 48 is to be invoked for withdrawal from the acquisition. Now, there are two things. One is withdrawal from the acquisition after a certain stage, and the other is withdrawal of the preliminary notification itself.
now correct.
My lord.
But then you withdrew only when after several years, isn't it?
No.
Officially you withdrew.
Officially, we will be immediately thereafter.
For
after
more
army-
than 2 years, the
Ah.
land was in possession.
Immediately after the army authority informed, we.
Now, when did you issue that withdrawal order? Which date? Because you issued a notification on 8/4/2009. And
Yes.
when was the withdrawal order issued? Formal
12
order?
10 2011 Lord.
Huh?
12/10/2011.
10/2011. So 2 years, more than 2 years. So question is now, you said we don't require. The army said we don't require with low lying.
Right.
I mean, they must have done some survey.
Yes, Lordship, that's the.
But
They
this
must
is-
have entered,
My lord,
the
this-
commandant must have said, you
No,
go
my
and
lordship-
see whether it is fit or not.
Lordship,
Then he
can you
said,
see-
sir, we found it is very
Factually-
dangerous.
My lord, Factually, after the preliminary notification issued, when they found that land is low, for
How do you say the land
My lord,
low lying
my lord,
area?
for assessing the status of the land, whether it's low lying or not, survey is not required. One site is enough. They have decided not to go ahead. They have
You mean to say
immediately-
the army official was standing on the road, they saw it and they say no,
They never came.
they never came.
My lord, this is the finding of fact by the honorable single judge, that they said their stand was defined, my lord. They want compensation under 48 too. And that is why we filed the affidavit, my lord.
Been found. reference to their ALP plan. Okay.
My lord, this position.
See, we can, Mr. Your own collector,
My lord.
ask him to make a inquiry whether there was any entry or by any of the officials, army officials, and whether any damage was done, give the opportunity to villagers. You make your own record. If they say nothing, finish. If you say something, when the matter is.
That can be done, my lord. Just.
There is no point keeping these
My lord,
matters.
my lord. Yeah, I understand.
You should be fair also. Government, see, the public, the grievance, the villagers, they feel that there have been damage has been done.
There is
You
one.
find
My lord, there is one.
because as per section 5, what the collector can make.
Yes, yes.
So let the collector make an
There is
investigation.
no difficulty in assessing whether any damage was caused. But difficulty here is, my lord, the person who files the petition is filing the petition with a bigger idea of collecting huge quantity of compensation in terms of section 48(2).
Now he cannot get
I'm
it.
just-
The villagers will get now.
Give me just 1 minute. What has happened during the deliberation? My Honorable Justice Tekya will recall, because court number 1, ultimately the deliberation from the deliberation that took place when it transpired that actually this notification under section 48(1) by us for withdrawing from acquisition ought not to have been issued. It is the preliminary notification under section 4 itself.
We have no issue on that. We okay, we understand. We have understood your.
Beyond 4, you did not travel.
Beyond 4, we didn't travel.
Okay, very well.
And there is a, my lord, and there I have mentioned that 62 Supreme Court clearly says that if the notice under section 11 is not issued, then withdrawal of the preliminary notification itself will suffice.
Okay, we are not on the legal issues now.
Your lordship is correct that if notification under 4 was issued, then 5 years to assess whether any damage was
Yes,
caused.
yes, yes, let-
That exercise was done. Even then, if your lordship wants a fresh exercise to be done, we'll do it. Ma'am. There's no
do it, finish it off.
Only lordship
Let
may-
the people be happy.
My lordship may only take into in the affidavit we mentioned. I'm just again pointing out because it was not annexed. I am saying.
What was that?
In the writ appeal.
In a,
By the speaking order, we disposed of that part also. Lordship-
who has issued the speaking order?
Collector, I think.
Collector.
Is it enclosed somewhere?
Let
It
us
is-
see the
It was
collector's.
enclosed with the affidavit of opposition, but they have not enclosed with the writ appeal. Ma'am.
Oh.
Let us see the collector's disposal.
My lord. In the
Order
affidavit of
sheet.
opposition, paragraph 7, we mentioned we
See the
annexed.
business, Sekadatan, their sanctions. Collector. Collector has done it then.
My lord, that is what I'm saying.
Why are we not enclosed to the writ appeal?
And they have not enclosed.
Collector has done job. We should not use this judicial forum for on and on. You see, go to Ujan Bazar. In the roads are all, sidewise, all vehicles are parked. You are not supposed to park. Huh? But then people park the vehicles. Then what happens? So all traffic jam. So these kind of vehicles. These are another vehicle. Writ appeal is another vehicle parked on the side. There is no point. Take it out. Parking. Khali koribo lagibo. Otherwise, we are not able to spend time for hearing urgent matters. We are all waiting.
Yes, sir.
We'll satisfy, inspire you, do it again. Doesn't matter.
If your lordship directs. ma'am,
Okay,
we
have
will-
Mr. Lane counsel for the Central. Lane counsel for the. Yes, madam. What is your name?
Ms. B. Devi Lodge.
G. Devi Lane counsel for the applicant. Also, Mr. Lane, additional president for the state, assisted by Ms. Venka. Also, anybody else? All the respondents. Oh. The present appeal has been filed against the order dated 25/8/2017 passed. 17?
Yes, sir.
Passed by Lane single in WPC number so and so. By which the petition filed by the writ appellants seeking for a direction. Okay, we'll pass the order.
My lord.
Will you again conduct the order, hear them and just give notice to all those people, hear them, anything, if they can prove some
Only-
document.
Only thing is, my lord, yeah, it's not a case where poor villagers have come. There are some, lordship knows when in land acquisition what happens.
That,
The leader will come
then the
and
collector
it will.
redo the exercise
My lord,
and
my lord,
that's appropriate.
my lord, if compensation under 48(2) is to be granted, it will be a huge burden on the exchequer.
No,
unnecessarily.
only for damage,
My lord.
damage cause, then you
We
can
are
do.
not even going into that.
We are not going
We
to
are
that.
Only looking into this aspect of whether 42,
I have understood.
48(2) is at all required.
True, my.
So any event, if any damage has been done as alleged by the, you can look into it, that can be done by a local inquiry by the collector.
Well, your lordship direct the collector in 1 second. If
Yes,
your lordship direct, my lord, he has to do it.
yes, let it be done. Then we'll get a quietus to this case, yes.
My lord, not necessary to keep it pending.
Next.
Deeply open.
Item 10.
Bishuram Chauhan, yes, Mr. Chauhan, what is this from?
My lord, interest, my lord, not my lord paid. And my lord, learning single judge also not my lord. Despite of my repeated submission, my lord, not my lord.
What interest not paid?
My lord.
Only should you appeal is whether the applicant will be entitled to interest on the date position of land. Yes. Are they entitled or not entitled?
In fact, my lord, they said, our stand in the reputation was that the land was, in fact, there was an existing road in the land and it was only developed. And in the year
We
2000.
don't know what is the fact of the case. Is he entitled under the law or not?
My lord, there is no scope, my lord, to open the fact, my lord. Only, my lord, limited point, my lord, the interest under this is.
No, I am
So you are claiming the interest under what provision of law? Tell us.
Section 880, my lord, new act.
Let us see what the law provides.
2013 Act.
2013. This is a new act or what?
New act, all act, my lord, same provision.
Okay,
In both-
but your land was acquired under the new act.
My lord, can be said by new act.
No,
but
don't
my
say
lord,
can be
my
said.
lord,
Please give us one answer.
formally
Was it under the old act or new act?
The amount was calculated under the new act.
New act.
In the year 2013, my lord, after the honorable court ordered, although according to him, the land was used in the year 2004, but pursuant to honorable court's order only, it was calculated by the deputy commissioner in the year
But
2013.
we cannot override the statutory provision. That's why we want to know. What is that? What is that?
Section 80, my
Section?
80. My lord,
Payment of interest 42.
statutory provision is there.
Power to enter and take possession. Huh? What is that section?
Section 80, my lord.
80. Payment when the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount or with interest thereon. So when the amount of what is the amount of compensation, Mr. How
My
much?
lord, total amount, my lord, 5,26,000.
5,26,000.
680. Out of that-
680.
Out of that.
This was supposed to be paid on or before when your land was taken possession.
March, my lord.
Oh, I'm asking the date. Don't say much. We don't know what is this much.
March 2004, my lord.
March
2004.
March 2004.
Yes.
Your land was taken possession. Yes, Mr. Nag, do you dispute this fact?
But
No, please ask. Then you explain
Yes.
anyway what you want.
Yes, yes.
Do you dispute this fact that you have taken possession of his land in March 2004?
but there is
And
some,
if so, then when did you take possession? Tell us.
but there is some dispute, my lord.
No, okay. Then dispute. Then
the-
when did you take possession?
But it was an existing road. There was no complaint from the petitioner that was developed. So then only my lord, he raised his objection, and in the year 2012 only, pursuant to this honorable court order, my lord, in the year 2013, deputy commissioner has assessed the amount, my lord, and
You mean to say that this was already a road, public road?
it was a public road. That particular land was used for public road for last.
No. Maybe but it may belong to him. That doesn't mean that,
Finally, only after the,
when did you develop the road?
it was developed in the year 2004.
Huh?
It was developed in the year 2004-5.
So from there onwards, you have dispossessed him.
For last 30 years, he was not in possession of that particular land. It
Okay,
was a
because
public
you're
road
already a
only.
public dog.
Malad, under the PMGSY, Prime Minister Gramya Swaraj Yojana, malad, in the affidavit we have filed, it was developed under that particular scheme in the year 2004. It was an existing road and which was used by the public without any objection.
He may give his private land for whatever, for public use, public grazing, public meeting. But it is his land till it is taken over by you. That's what you understand legal.
True.
Then,
Then? Well, in the year 2013 only, the deputy commissioner has assessed some amount and that was given to us. Accordingly, it was paid. That was again revised under the new Act, 13 Act. It was assessed at 5 lakhs and some thousand rupees. Now some portion of that amount is required to be paid. It was according to the appellant, it is still not paid. That is kindly see page 54.
and
of
as
the-
regards the interest portion, what did the learned single just say?
The interest-
No
interest
objection
has
is
not
there.
said, right?
Uh-huh.
No objection is there, my lord. My lord, but my lord, I repeatedly submitted, my lord.
Just a minute.
My lord, they have not preferred the writ appeal, my lord. Challenging the fact, my lord. It is my lord, my lord, prefer the writ appeal, my lord. So, my lord, of saying all this, my lord, if they file, my lord, affidavit.
What is your prayer? Come to page 30. Don't ask for more than what you asked for. Page 30 of your writ appeal.
Well. Because, my lord, out of.
Of the data from the petition at a rate of 1 and thereafter until payment after hearing so with interest from the date of determination on. So you want from 2014, you give from 2014. That is what you asked for in the writ petition.
Yes.
Don't by filing a writ appeal, don't ask something more what you didn't ask in the writ petition. Mr. Chauhan, is it okay? We'll close it. Don't ask more now, just because we are sitting two.
Your lordship,
You can't.
I leave
You-
you to alone.
No, there is nothing to be left. You said, Mr. Learned Counsel for the appeal, House of Learned Counsel. On perusal of the on perusal of the pleadings, we find that the appellant petitioner made the following relief claim, sought for relief claim. From the above, it can be ascertained that he was seeking interest on the amount due from the date of determination on 19/4/2014 at a rate of 9% for 1 year, and thereafter at the rate of 15% till payment. The 15% we can't give you. Can we give?
My lord, yes, my lord, provision
Okay.
is says so.
Okay. Under circumstances, in the present appeal, Learned Counsel for the appellant submits that he was dispossessed since 2004, and as such, he shall be entitled to interest also from 2004. We are not inclined to entertain the said plea, inasmuch as said plea was not taken in the writ petition, as his prayer was for payment of interest only from the date of determination of 19/4/2014. Under the circumstances, we modified the direction of this learned single judge for directing the authorities to pay the interest as mentioned under section 80 of the Right to Fair so Act with effect from 19/9/2014. Appeal stand disposed of.
Well, some amount has already been.
My
paid.
lord, one clarification, my lord.
Only on the unpaid
Yes,
amount.
the amount.
My lord, partially payment is made, my lord, rupees
He has claimed the
3
interest
lakh
on the unpaid.
180 remain to pay.
What?
Yes.
Any amount already only due also shall be paid forthwith. How much is the amount due?
My lord, 3 lakh 3,180.
It has been submitted by Learned Counsel for the appellant that in respect to principal amount, a sum of rupees 3 lakh
3,180.
is required to be paid. Is it correct, this amount? Which is not disputed by Mr. Nad Learned Senior Regional Government for the state. In view of that said amount will also be paid without any further delay.
But he has claimed the interest only on this amount.
Okay.
Only on the unpaid amount.
Okay. So accordingly, the authorities will pay the interest at the rate as prescribed under section 80 of the Act in respect to approximate amount of rupees 3,00,000.
3,180.
My lord, today respondent number 1, 2, and 6, my lord.
1, 2, and 6. Huh?
Yes.
The concerned respondent 1, 2, and 6 will do the needful.
Much.
Is that correct? Yes, next.
Timing item 6.
What is item number 6? Mr. Majumdar, 2018. You had first condoned his age, first time.
That was for that particular recruitment process.
But if she was still 45, she could apply. Next, she was under impression that you've been condoned.
Could not have been, my lord, because the advertisement was very specific. And it was never her case before the Honorable Single Judge that my age having been condoned, I had applied. She never made that.
Now, except for the age, any other problem with her?
My lord,
Can she speak? Can she write properly or eligible to teach? Was she found suitable?
my lord, that record I do not have, my lord. That
Oh,
record-
you first find out whether
Question
Mr. Majumdar will inform this court on the next set as to the suitability of the respondent number for appointment to the post of.
Assistant teacher.
You find out.
Barring her age, that lawsuit, otherwise again I'll have to come back
Yes.
with that
No,
instruction.
barring her age.
Because
barring
at
her-
age 12.
Barring her age,
it
means you want to see, because if she has not done well, then we can. But if she has done well,
Then
she's the
she
top
will
of
not
the
be
list,
before the-
then is okay, next week.
My lord, the advertisement criteria, my lord, it's very specific. She
Yes,
has to-
Mr. Majumdar, don't worry, we leave it to us. That is why we have been appointed to sit as a judge there. We'll decide certain cases, right, wrong, huh?
Lordship,
You have done your duty, we'll do our duty. Just give the instruction as to what is the suitability, what is the merit position. Except the is.
17th February.
Yes, next.
Item number 11.
Sofika Hussain,
Yes.
what is this, Sofika Hussain?
Appellants are the bona fide purchaser of two plot of land. They have purchased the land by way of registered sale deed from the husband of the respondent number 3. Accordingly, their names were mutated. Subsequently, the respondent number 3 filed an appeal before the ADC stating that the land was originally gifted to her by her mother and brothers, but her husband fraudulently got the name mutated. And while counting such mutation, out of 8 pattadars, 6 pattadars has given consent in the Sitha book, 2 pattadars have not given. So thereafter, ADC passed an order, cancel the mutation of her husband as well as my mutation. My mutation was effected on the basis of registered sale deed as well as possession. Also, land is in the possession of the appellant. So ADC has passed the order dehoring the section 41 of the Assam Land and Revenue Regulation. The question, when the question of title comes, Revenue Authority has to refer the parties to the civil court. But without doing so, he has cancelled the mutation of the husband of the respondent number 3, as well as our mutation. Against that, we preferred an appeal before the Board of Revenue. Revenue Board also dismissed the appeal and rather decided the title of the husband of the respondent number 3, that he has no right, title and authority over the land. So against that, we prefer the repetition, and repetition also dismissed.
So the land belonged to the woman. Initially, according to them, the land belongs to the wife.
No, Lordship. Land belonged to their mother and brothers,
Mother, and given to
given to her husband.
husband.
Husband sold us to us, sold us by way of a registered sale
They
deed.
did not give to the sister, but to a husband. A very husband is very loved by your in-laws, no? That they gave the land to the husband. Then the husband sold.
Yes. Also kindly.
So what is to be done today? Yes, madam, what do you want today? Is it for disposal? What?
My lord, hearing is required in this case, my lord.
Hearing is required. Will hear you are still in possession.
He's still in possession.
Okay.
But records need to be called for every year.
Okay, record. Okay. We'll call for the records then. And Mr.
Estaca.
learned counsel for the appellant. Or also Ms.
SG Borga for
S.B.
respondent
Borba for
respondent number 3.
respondent number 3. And you are for
And does for 1 to 4.
1 to 4. All are represented?
My lord.
All are represented?
My.
Let the matter be heard. Since the parties are represented, matter can be heard finally. In the meantime, call for the records. Records from where?
Assam Board of Revenue.
Assam Board of
Revenue.
Okay.
Item 12.
Ajay Das, why did you file this appeal? What
This
happened
is
to you?
against permanent alimony of rupees 10 lakhs. my lord.
10 lakh. And
The-
who are you?
I am the husband, my lord. Husband was granted divorce by
Divorce,
the family court on the cruelty by the wife, my lord.
cruelty by the wife.
Yes, my lord. And thereafter.
And what are you
There
doing?
is a daughter. I am a government servant, my lord.
What, how much you are earning?
30,000, my lord.
30,000.
There is a
Yes.
daughter, my lord. She refused, the wife refused to take the daughter. Daughter is with me, my lord. She is studying in class 3. I
Okay,
have parents, my lord.
okay, we'll issue notice. And Mr. Das, issue notice renewable 3 weeks. Appellant to take safe subject responded by rest of post with AD. Dusty also allowed. You want to go, you want to be, you are afraid to go because you said that the cruelty by your husband,
Yes,
your
my
wife.
lord.
You are afraid.
Dusty may not be.
That's, we'll get. Okay then. Rest of post with AD.
I have a small interim prayer.
What interim? Sorry, without hearing the lady.
Lordship, lordship. Much of it.
If she can be violent to you, she can be violent with others also.
13 and 14.
Much of it.
Yes, yes. 13, huh? Manipur hockey, what Manipur hockey is doing here? Anybody? Yes, we'll issue notice. We'll appeal. Anybody for appellant?
14.
Huh? Yes. Anybody for appellant? The matter has come up on being transferred by the Honorable Supreme Court. However, none appears. List the matter again after 2 weeks. By showing that, yes, you are there. You are there in this hockey. Item number 13. You are there? No, nobody is there. 13, 14, anybody here? This is the matter after 2 weeks. At a time,
Yes, sir.
so to enable the parties to appear before this court. Yes.
27 February.
Union of India.
Item 15.
Jayan, what happened?
My lord,
Huh.
one of the important order of the Learned Single Judge has left to annex in this petition, my lord. I may be allowed to fix on Friday, my lord. Tomorrow I'll file the petition.
Or next week or
No, no,
urgency. Okay, urgency. Okay.
Ask the-
Friday on the prayer of Miss Jain. Yes, next.
10 February. Supplementary list for admission, item 29 to 31.
Item number?
29 to 31. Supplementary list.
What are these NC Das infra? Oh, that forest. Yes, Mr. Forest.
But I would like to.
Mr. Gogoi. Mr. Gogoi, you are for whom?
Forest Department, my lord.
Forest Department. Are you involved in this contract?
My lord.
Are you party in the
I'm not
contract?
a party, but.
Very good. Please sit down.
No, but material.
Please sit down. Please sit down. Please sit down.
My lord.
You are not a party, you are a stranger. Yes. In contract,
Yes,
as per contract law, if you are not party to the contract, you are a stranger.
yes.
Very good. Yes, Mr. Gogoi, another Gogoi.
Lordship.
Now, please tell us, you are the railways.
Lordship.
Have you been authorized by the government of Assam to collect this cess royalty from the?
Lordship, railway indicate in the terms and conditions of the contract. that-
Oh,
Lordship.
indicate, don't say indicate.
Yes, sir.
In terms and when it comes to contract, the terms of the contract. Have you been authorized by Mr. Gogoi to collect the from
In
Mr.
terms
Da?
of contract, Lordship, the contractor has to pay Lordship as per the.
Fine, if he doesn't pay, then what will happen?
Because the materials.
If he doesn't pay, then what will happen?
Then
What's the
Lordship,
consequence?
then the
He
action.
can be sent to jail?
No, Lordship.
Then
It should be recovered from him,
who
Lordship.
told you? Where is that, where is the provision in your contract that yes,
Notification is there, Lordship.
This notification
Assam
issued
government
by whom?
notification is there.
issued by whom?
Issued by the Lordship, Government of Assam, Lordship.
Government Assam is not part, you are not part of Government
Because
Assam.
the materials.
You are not part of Government Assam.
Lordship,
You are under the ministry Yes,
Lordship, but
you are under ministry, you are under,
Show us a circular from the railways or
ah.
financial rules.
Materials are taken.
Does
from
the
government of
Assam government give you any commission to collect this royalty from them?
The Lordship, the
How
material.
do we also know that the royalty which has been collected by you from them will be transferred to the Assam government?
Those are collected from the
So
government.
that
of Assam,
if
Lordship.
there, what is the internal arrangement between you and Assam government? You don't know. It's not part of the contract also. So you inform the government of Assam that these people appears that they have not, so they will be after them.
Clause is very specific, Lordship.
Huh?
Contact clause is very specific.
Very good.
Very
What does it say?
It says that, Lordship, wherever, Lordship.
Yes,
Lordship.
yes, tell us.
Forest produce like sands, stone, timbers, etc. used in the work.
Yes.
The contractors will have to furnish documentary proof that requisite royalty on such produce has been paid to the concerned department.
Very good.
Here, concerned
Suppose if he
department-
fails to do it, suppose
Lordship,
if he fails to do it,
Lordship,
then what will happen?
Lordship, then.
What is the course of action?
Lordship,
Suppose Mr. Gogoi,
Lordship,
a lawyer fails to appear in the court.
Lordship,
Either you can adjourn,
Lordship,
either you can dismiss,
Lordship,
either you can continue here ex party.
Lordship,
Law provides various means.
Lordship.
So if he doesn't pay, if he refuses or if he fails to produce this certificate, what is the course of action up to you?
Then it will be deducted from the bill, Lordship.
Where is that provision?
Lord-
Tell us that. Where is that provision under the contract?
Because, Lordship, he has to produce the source of, Lordship.
Correct.
He has to, even, Lordship, that particular judgment. Durga Krishna store, Lordship. Durga Krishna store, Lordship, may kindly peruse Durga Krishna store, Lordship.
Why is it Durga Krishna?
Durga Krishna store, Lordship. That party, that day we have given, Lordship.
Oh, Mr. Goswami, let us hear one by one. We again remind you again and again that we have 2 years, but both the years are focus only one voice.
If, Lordship, he can produce the source where he has paid the.
Oh, again, Mr. Gogoi, why you are worried? You tell this, you inform this another Gogoi. See, this person has not paid the royalty. You do action against him. You are not the collector of royalty. Are you the collector of royalty?
Kindly peruse paragraph 8, Lordship, Durga Krishna store.
And in Durga Krishna, this appellant, he was working under, he is engaged by whom?
Lordship, railway, Lordship. Same supplier. Lordship.
Railway deducted the security.
Paragraph 8, Lordship. If he proved that the source he has paid, Lordship, then we have no case, Lordship. Even, Lordship, the judgment which was put to challenge before the appellate court, Lordship. 2002 notification আছে 2002 notification
Acha, Mr. Goswami, they have deducted the amount or what?
They are not releasing the
You,
final
Mr.
bill.
Gogoi, you release the balance, we'll see what about the deduction. Don't keep it holding. Keep whatever is due to him, and how much is the amount which has been deducted?
Reduction is
In
not
fact,
yet done, Lordship.
How much you are entitled to get?
They are insisting from FRCC that forest royalty
No,
clearance
we will
certificate,
meet
and
exam.
they're paying their final bill.
You pay whatever except that one, you
Lordship,
keep that,
except
release that.
by deducting that particular portion, Lordship.
How they are not
No,
empowered.
We'll hear this appeal.
Lordship.
Mr. Goswami,
Malad.
in the meantime, take this on your pocket. You are a
No,
businessman.
this is-
You use that for your future.
Sales amount,
Ah.
Lordship, the royalty.
You take whatever is given, that amount will subject to what we'll see that will be subject to, because we have to hear, because what has happened is
No.
that, see, Durga,
No, that has been clarified by the Learned Single Judge in the impugned
No,
judgment.
see,
That paragraph.
Mr.
352.
Mr. Goswami, this is clarification of a division bench order by a single judge. We have to
Madam,
be
include
careful,
that,
because see, there are 2 division benches. One is Ali, one is Ali,
Malad.
and
Another
Wali is in your favor,
Malad.
correct?
Another is-
Now this Durga Krishna is again against you.
That has been placed for Learned Single Judge. Learned Single Judge-
Correct.
Definitely.
But
Okay,
then
it's required to be-
nevertheless,
Malad.
this is a division.
Malad.
Ha.
Even,
Therefore, we'll hear this.
Malad.
See, apparently before us,
Lordship.
we are also low students, huh? Judges, we are so low students. Apparently there are two judgments. One is Ali and then this Durga Shankar. There is some appears to be certain, I won't say contradictory, but there are some, areas where they don't meet everywhere. Huh? So there requires to be resolved either by us or by a larger bench. Okay.
Lordship, not only Durga Krishna, it was also decided by the Bijapur also, Lordship. Bijapura also, Lordship.
Okay.
Yeah, division bench judgment.
Okay.
Lordship.
So we'll examine that. We'll examine that. But in the meantime, you take whatever is given. Huh? You
That's
take.
by deducting the first royalty.
Yes, you
part.
deduct it.
Otherwise, it will be not.
Deduct and that, yes, that money.
You may observe that deducting the first royalty.
And that
part
amount it will be, whether it will be refunded to the applicant or not, will be subject to.
decided subject to the authority. Lord.
See, your deduct will be 7,000 or something. Because you are not taking the 8 lakhs. Take that 8 lakhs. If you invest, okay. Because this is an area we have thought it over. Because apparently there are some issues which requires to be reconciled. Okay. Is it okay? Then we'll fix for hearing. In the meantime, you take whatever is money. And that deducted amount will be subject to the final as to whether it will be repaid. Mr. Gogoi, you have to be prepared that money. If he is successful, you have to give it back. So do whatever you want with that money. But then, yes, if he is successful.
Observation, even the Supreme Court also says that lawsuit. If statute shows that lawsuit, then it will be in here. It is the state of the Assam government. It is their lawsuit.
Okay.
Apart from that, my lord, what I was trying to say initially, my lord, that AMC rules, my lord, minor mineral rules also prescribes, my lord, it falls in a schedule and prescribes a rate, my lord.
Correct. We are not denying that. We are not denying that. If he is your government, if you are a PWD, we can say, well, 2,000 is applicable. But he is a railways say, this government of Assam, we are not bound. What will you do?
Lordship, because
You are not government. Railways is not an employee of the government of Assam. So if the railway says, okay, these are all railways, they are government.
materials which are from the government of Assam. Lordship.
Okay, whatever it is.
Even
So
what
we,
my lord have also decided that it should.
and Mr. Lanet Counsel for the appellant, also Mr.
And regarding Muslim Ali, my lord, this is again, my lord, today petition listed, my lord.
Mr. K. Gogoi for the railways, standing counsel,
Railways, Lordship.
and also D. Gogoi
Well,
for the state
forest.
forest. You are the standing counsel.
Standing counsel forest department.
Okay, forest. In this appeal, the issue is primarily focused on the question as to whether the appellants, whether the railway authorities can deduct the royalty in respect of, what is that, ordinary arts?
Ordinary.
In terms of clause 13(2). In as much as it is a contention of appellants that there is no provision for deducting at a time of final settlement. There is no provision under the terms of the contract between the appellant and the railway authorities for deducting the royalty at a time of final settlement. On the other hand, it is the plea of the railway authorities that, the same can be done. Respective counsel have placed reliance on, Lanet Counsel for the appellant has placed reliance on Durga Krishna. Muslim Ali. On Islam and other decisions. On the other hand, Mr. Lanet Counsel for respondents have placed reliance on Durga Krishna store.
Durga Krishna store as well as Lordship, the Bijapura Cooperative.
And the Bijapura?
Bijapura, state of Assam. GH Bijapura, Lordship.
Can you kindly give a copy? Division bench. A state of Assam and others versus GH Bijapura and others.
2017.
2017 3GLT 478.
Lordship.
We have the view that in view of the two decisions cited by the rival parties to substantiate views, it will require further examination
Lordship.
under the circumstance, let the matter be listed for hearing. However, in the meantime, the railway authority shall release the due amounts to the appellants, except the amount of royalty
Lordship.
which the railways are seeking to withhold, which payment to the appellant will be dependent upon the result of this writ appeal.
Lordship.
List accordingly, huh?
My lord, one line may be recorded, my lord. I have pointed out a notification of 2009.
Okay.
2009.
Mr. D. Gogoi, Council, Standing Council for the Forest Department also has relied on the
Notification. my lord, of
notification.
2009, Forest Department. my lord. Notification of 2009
Around 9.
of Department of Forestry.
Okay. Yes, next.
In March. Item number 32.
32. Binod Sonwal.
Matter pertains to termination of a Grameen Dak Sevak, my lord. Similar matters have been disposed of. So my learned friend on the last occasion.
Yes, my lord. There is similar matter, only one information I don't have, my lord. In earlier petition, my lord, the observation was there on specific query made to the learned Assistant Solicitor General of India, appearing to the respondent, even this court has informed that the post of Grameen Dak Sevak to which petitioner was appointed is still lying vacant. Otherwise, the case is similar, my lord.
Is it still lying vacant?
I'm not aware that
So
instruction.
if he is lying vacant, you have proof, huh?
Yes.
Subject to the condition, huh?
Yes, sir.
Okay. And Mr. Lane Counsel for the appellant, also Ms. Gayan Lane CGC for the respondent purpose. The present appeal has been preferred against the order dated. Where is it page?
My lord, we take up the judgment, my lord. There only the dates are different. Page 81, my lord.
Page 81. This
Page 81.
judgment and WPC number 4750, huh?
Yes, my lord. The petitioner before this court has challenged the order.
Dated 1712.
No, my lord, lordship is.
No, which one you are challenging?
No, I'm referring to the similar order, my lord.
No, correct. But in this petition, you are challenging the order of CAT.
Order of CAT, my lord. That is at page number 61, my lord.
Page 61.
61. 4419.
Page 6. The order dated 22/1/2019.
No, my lord. 4/4/2019 passed in OA 66. Page 61, my lord.
Page 61 is date of hearing. Okay. What is the date of order?
It's 4.
Okay, 4/4. Order dated 4/4/2019 passed by the Central Institute Tribunal Guwahati bench in original application number so and so page 61, by which the plea of the petitioner for appointment to the post of
Grameen Dak Sevak Mathavani
was dismissed on the ground that the said post was reserved for OBC and applicant was an ST candidate.
Yes.
Petitioner was already employed. Then he was terminated.
Okay. If my lord refers
It has
to
been,
common judgment, my lord, there only the dates are different, but
Okay.
rest everything.
It has been submitted by Lane Counsel for the appellant that similar issues have been already decided by this court in, what is that judgment?
My lord, the first one, page 81, my lord, annexure N.
Page 81, huh?
Yes, annexure N, and the
Have
second
been
one.
only, this in WPC number 4750/2021,
And WPC number 4690 of 2021.
whereby
Page
this
9.
court had allowed the petitions with the direction to the respondent by setting aside the termination orders,
And reinstating.
and the
within service,
reinstating service,
And by granting back wages, my lord.
and also granting back wages. The order passed by this court in WPC 4750/2021, effective portion of the order passed by this court reads as follows.
Yes, my lord.
Page 91,
91, my lord.
full stop. Similarly, the order passed by this court in 4690/2021 are as follows. Page 5, page 95, para 5. 5, 6, 7. Today, according to having submitted, since the present petition is similarly situated, that the petitioner in the present petition is similarly situated, is those petitioners in the aforesaid two petitions similar order may be passed.
District Google.
Ms. Gayan also having examined this, has examined the matter, also submits that since the petitioner also similarly situated as those two petitioners, similar order may be passed. However, she has no instruction as to whether there is still vacant post or the
GDS BPM Mathawani.
and this under second we allow this petition with a direction to reinstate the petitioner, provided there is a vacant position available as on date.
Just one prayer, my lord.
If not, she may be adjusted against any
Yes.
other subsequent vacancy which may arise.
Deeply obliged. My lord,
With the-
in the district of Dibrugarh, because
In
they
the,
have the local.
in the office, please give the details.
My
please
lord,
give details,
I'm very grateful, my lord. I'm deeply obliged.
With the above, that the present petition stands disposed of. Yes, next.
Item 33.
Food Corporation, FCI, what has happened, FCI? Anybody for FCI? Yes, yeah.
Not in this case, what happened,
Ah.
learned single judge passed the order based on a earlier judgment of any trade, where the facts were little different.
No, what is to be done today?
Let it be admitted, matter may be had.
Anything, yes?
My lord, only thing is that, my lord, security
deposit
deposit
of
of
around
around
75
75 lakhs is lying, my lord. They are not releasing it.
Why are not releasing?
Security can be released,
Why release? Why you want to keep the money?
Security can be released.
75, nothing for you, but big for him.
So far security is concerned, I think.
They have to file, they have to submit a no objection certificate, my lord. Then we will release the security. my lord.
Only
Obviously, we will
security
release,
deposit.
we will-
How can I say no claim, because it will have to be without prejudice to my rights in this case.
Whatever it is, whatever they want is some papers. You know how in India works, everything document, kagoz ahibo, NC lahibo. Give it. You have.
Lordship will kindly make that observation that it will be without prejudice to my rights in the case.
Okay, certainly. Second.
Yes.
Okay. Our learned senior counsel, assist by so for the appellant, also Mr. Das.
And Decca, my lord.
Sorry, Decca for respondent number.
So respond, my lord.
For respondent. The matter be listed, it has been submitted, the matter can be heard finally, accordingly let the matter be listed for hearing in usual course. However, in the meantime, the security deposit of the respondent number one may be released by the FCI authorities on furnishing a no objection certificate. It also goes without saying that this will be without any prejudice to the claim of the respondent number
Respond number one.
One in the
in
present
the present petition. In the,
Stay of the impugned
I
judgment.
mean, the stay of the impugned judgment
Ah.
and order dated 13/9/2022 passed in WPC.
except for the above observation made, the remaining part of the judgment will remain state. Huh? Isn't it?
Judgment and order dated matter.
Order dated so and so and so.
Oblige.
Yes, huh? Yes, next.
Daily
item.
list for orders, item 16.
16.
Please, your lordship. Sir, this is with regard to that construction of road at the Malibagan. I am praying for Mr. S.K. Das, my lord. On his behalf, I pray that the matter may kindly be taken up at 2, my lord. Please.
Okay, next after 2 weeks.
My lord.
Any problem? After come
No,
after 2
the
weeks?
report was to be submitted, my lord. I
After,
think it's
after
with-
2 weeks?
No, my lord, no.
No, okay. This after 2 weeks from the pair, Mr. Lani. Yes,
Item 17 and 18.
State of Assam,
Yes, my lord.
why you are filing this? What is this appeal?
This is regarding, my lord, your respondent, the petitioners, they filed a writ petition.
Yes,
They
correct.
they filed a writ petition
Seeking what?
seeking appointment
Ah,
on the basis of the qualification acquired, TET qualification acquired for 6th schedule area.
okay,
They have been allowed to appear in the 6th schedule area TET, my lord.
yes,
They successful in that examination, my lord.
then,
But 6th schedule area TET is for only for 6th schedule area. They cannot participate in the general TET, the
Okay.
general selection process, my lord.
then,
They have participated in the general in respect of Borpeta district, my lord,
okay,
and they have been selected.
then,
But government rejected their claim since they are qualified for only for 6th schedule area, my lord.
okay, then what happened?
Then learned single just allowed their petition, my lord. Against that order, my lord, we have prepared the writ appeal, my lord.
Okay, learner single is allowed. For which post?
Post of assistant teacher, my lord.
Assistant teacher.
So otherwise, my landed fine is appealing, my lord. May I pay the matter may come up for admission, my lord.
Otherwise, my lord, that clause, what has been, my lord, published by the government, that was not, my lord, at the time of advertisement. And certificate also, that clause is not there, that they cannot apply.
And and this too, and this order was passed by the learned single judge when?
In the year 2017, my lord. 26, 2017.
26, 2017.
Yes, my lord.
And you are still out of work.
Yes,
You have
my
not been appointed.
Not appointed.
And post of what?
Assistant teacher, my lord.
Assistant teacher.
Our names appeared in the selection list also, my lord. Subsequently.
And
they-
was a stay order passed by this court? Was a stay order passed by this court in the appeal?
Yes, my lord.
Huh?
Appeal, it was stayed, my lord.
It was stayed. 5 years, 6 years later. Where is the stay order?
But in view of this pendency of this case, my lord, they have not proceeded.
Why? We appoint, we'll see. You appoint, there is no stay order, or you appoint 5 years, we have not, they would have survived.
But,
And they would have, some of them who get married also with that money. Now they can, I have all married or what? Boys,
Yes, married, my lord.
all married.
Yes.
Okay. At least they can give better food to their family.
what-
You have depriving
Regarding
them.
the present status, I'm not aware, my lord. So, my lord, may fix it on next week, my lord. My lord, may fix.
6 scheduled areas, so what? So they are also part of this country or
Yes,
different
my lord.
country?
That is, I'm not disputing,
Huh?
but in the, they are in certificate also, my lord, it is
Huh?
reflected that they cannot participate in the
No, no, no.
recruitment process, which is meant for the general area, my lord.
No,
But then why did you allow them to participate?
That was the mistake done by the department authority at the time of verification of the document, my lord.
Why is it, why is it, why
Finally-
is it?
certificate, my lord, they have annexed only for your lordship.
Yes, let us see the certificate,
Page, my lord, that is 35. There is not mentioned.
page 35.
Yes, my lord. That certificate. 35.
Bornali Deka,
Yes, my lord.
child development pedagogy. You mean to say that this quality of TET in 6th schedule is inferior? Huh? You mean to say that quality of TET is inferior to the quality of TET in Assam? Non-scheduled 6th schedule area?
There is a decision, my lord, page 18. Page 18 of the.
1957 Marxist so. Empowered committee teacher in Assam, government of Assam declares result following candidate. Why is that? There is no such condition here.
Page 18, my lord.
Page,
Page 18,
page 80.
18, my lord.
18.
This is a decision of the government, my lord.
And when did you take the decision?
2016 itself, my lord.
December.
Page 18.
Yes, my lord.
8 December 2016. And when was the advertisement issued?
Yes, my lord.
Advertisement issued on
38/16.
30
8/16.
2016, August.
August. my lord.
So
Yes.
candidates who pass this and so will not accept. This will be after 8 December.
Yes.
So what was the rules applicable in the advertisement has to apply. What do you say? Candidates who have passed TET for 6th schedule area, they shall not accept in the TET mentioned they cannot. Medium TET means they can apply for Bengali language. Eh? But this DECA is also Assamese, I understand.
No, no, first,
Decca is-
close one, my lord, close
Huh?
one, close one.
Close
Yes.
one.
Yes, my lord, I'm not test that.
The candidates who have passed TET for BTC and 6th schedule areas, they shall not accept it.
Hmm.
Huh?
Yes.
Except for what?
In the TET, a qualified certificate, those candidates, it was clearly mentioned that they cannot apply in general areas. That is not there.
They are not there also.
Yes, my lord. Subsequent advertisement, they have specifically mentioned, my lord. But in that advertisement, they did not incorporate it there, my lord. That's why, my lord, this, my lord,
Yes, what is there, Mr.
My lord, may take it on next week, my lord. I'll open a specific instruction on that, my lord, because I have also been in the grounds also, it is a specific ground, my lord, that it is there in the certificate, my lord.
No, but there is no certificate. This is annexure, right? What is the certificate? Show us the certificate. Why it is mentioned
My
that
lord-
they cannot apply.
My lord, may take it up on next week, my lord. It is there, my lord.
5 years you have waited.
I'm
5 years, for 5 years
Yes.
you have deprived this salary also.
I'm praying for 5 days, my lord. Only for 5 days, my lord.
5 days only.
Yes, my lord.
Okay. Okay, list again on so and so 5 days due. 2017 matter. There is no stay order. We also noted that there is no stay order. The matter listed after 5 days. Tariq due 5 days.
15 February.
We also noted there is no stay order against the order of the learned single judge. Yes.
Obliged.
Item number 19.
Julekha Wahida. What is this Julekha? I for what? I is for what?
I for showing cause.
Showing cause of for what?
I is for restoration.
Restoration.
I'll just say whether this petition can be closed according to me, subject to what your lordship may say. 1995, one select list was published for geology appointment as a subject teacher.
But without restoring this, how can we pass any order? It is already dismissed.
All purpose, yes, already stand.
Therefore-
Question of restoration doesn't rise.
You know why?
Because in the under the facts and circumstances also.
But at least we can pass the order.
yes.
We can pass. At least this,
Yes,
let
yes.
it.
Lordship, we have not been able to,
Mr.
SP Hussain.
Learned counsel for the applicant, how from Mr. Learned Senior counsel for the respondent. The objection, the petition application filed for restoration not being objected is allowed. Earlier, WA will stand accordingly, stand restored to its original status.
Service is not completed.
Oh,
Yes.
service not completed. How many people are there?
There
Oh, I see.
Service to respondent number 14 has not been completed.
Who is respondent number 14? Who is respondent number 14?
One,
Uh,
10,
Shri
10
Amulya
and 14.
Goswami.
10 and 14.
11 and 14.
11 has received.
Huh?
11 has received prior to the passing of order to the previous date. 11 has received notice, but respondent number 14 has not. We have not been able to reach respondent number 14.
So what to do?
Kindly give some time to us, Lordship,
Okay, list after 2 weeks
in 2 weeks.
on the third line. Yes, Nick.
Most
Next item number,
Item 20.
Matt Ramadas. Yes, Mr. Ramadas, what do you want? Srimati Ramadas. Yes. Please tell us.
Restaurant side is
It
not.
doesn't matter why you are worried about him. You want to appear for him also. See, you have not taken steps. Have you taken steps?
Lordship, can
Have you taken steps?
Yes, Lordship, can you see it?
Oh, have you taken steps, sir?
Yes, I have taken steps, my on 22nd night.
Taken steps. Okay,
Yes.
we'll wait for the rest are ready.
Yes, by the ready.
Okay. Or you want to serve by he also, Dusty also? No.
No.
No, you don't. Okay. Await service report, list after.
Item 21.
Mansur Ahmed.
Lordship, this matter relates to a termination of my contract, your lordship.
Huh?
Termination of my contract, your lordship.
So what to do now?
Lordship, there is nothing, lordship. There are some certain developments, lordship. So I'd like to file an additional affidavit to bring out of certain.
Okay,
developments.
Mr.
DJ Das, Lord.
Place for how long?
Lordship, 2 weeks, lordship.
2 weeks time to file certain documents. Yes. List after. Yes, next.
Item 22.
Sanjeev Sharma.
Lordship, in this matter, I have filed an affidavit for respondent number 1 today, Lordship.
Today. Have you got a copy?
Yes, Lordship, I've received the
You
copy.
want to go through it.
Yes, Lordship, just this afternoon only I've received the copy, Lordship.
So you go through it, list
Yes,
after
Lordship.
2 weeks. Huh?
Yes, Lordship.
List after 2 weeks to enable the petitioner to file reply in affidavit.
Lordship, they need to implement new respondents, Lord.
They will do.
Yes,
They will
Lordship,
see.
do.
If any implement of a new respondent required, the petitioner may do so. Yes.
What's of it?
Item 23 forbid.
What is this item number 23? What is to be done today? Yes, somebody was supposed to take instruction.
The UGC council was supposed to obtain the instruction.
Where is he?
I am here, lodge for the petition.
Where is UGC? Yes, any instruction?
Yes, Millard, the instruction is this, Millard, that there is a guidelines for the holding examination for the physically disabled persons.
Yes,
And that guidelines is also annexed by them.
yes.
UGC said, Millard, that we have to follow that guidelines. only.
What is that guideline? What does it say?
Guideline says that it provides for the facilities to be provided to such persons inside the examination center. There is nothing in the guidelines to say that you can hold the examination as per the convenience of that person.
So examination center, suppose, correct, inside the examination center, that is correct.
Right.
But when the guideline is silent on certain area Why can't be more little bit creative? Or you are
My
stuck
lord,
with that?
our hands are tied because.
What
of
do you
the-
mean your hands are tied?
Because
You
of
are
the-
tying yourself.
No, because of the judgment passed by the Honorable Supreme Court in Professor Yashpal and Odisha Lift Corporation.
What does he say?
It both these judgments say it will not, the territorial jurisdiction of the university has to be followed.
Okay, we'll examine.
Lord, can I just make a submission?
We'll to 1:15, we'll either at 2 PM or some other date. You tell us.
Some other day, my lord.
Lord, whatever is convenient, not the only difficulty is that the concerned student is continuously writing, my lord. And my lord,
Correct,
then I
correct.
have to
You know,
report
we want to
compliance to
settle
the
it.
Commissioner of Disabilities.
Settle it, but as you know, our Indian judicial system, we can't brush, we have to take, we have to hear, we have to do this. So whatever it is, what do you
Whatever's
want? Either
convenient.
2 PM or some other date? Tell us.
Some other
Next.
day.
Yes, whatever is convenient. Mr. Nair.
Your lordship may indicate, Lord, I will.
Okay. Mr. See, don't tie your hands so fast, so tight that you can't wriggle yourself out also. See, law has to be flexible.
It has to be flexible. my lord.
You consider this person who cannot travel to Sikkim. What do you do?
My
Think
lord,
it over, think
my
it
lord,
over.
this-
Be a
so
little
far as
bit creative, innovative, without breaking the law. You can always do that.
How are these online entrance examinations are being conducted?
Then you do that online
But
exam,
the-
you them.
But the online examinations mode for this, just like NEET and other exam, professional examination, entrance exam.
No, not just NEET. There's so many other examinations which are held
The
online.
format of that examination is different than that of the degree courses.
In fact,
You can
during
hire,
COVID, they
say, you can
permitted it.
ask, request some, you are the students from where?
He's from Pune, my lord.
Pune. You can ask some Pune University or college, request them to be that you supervise that, will do online, let them sit the examination, they will
Yes,
send it
whatever
paper.
conditions your lordships will impose. Lord, there is
I
no
don't
difficulty.
know. We just fail to understand these people just sitting tight.
Do you want people to study or you want them to be
My
undereducated?
lord, no, so far as my understanding is concerned, my lord, because of the fact this, the people cannot approach higher educational institution, go physically, that is why the purpose of distance education is, has been initiated by the central government. The question is that there are some other rules that governs the.
Oh, mister, that's why we are saying, see the rules. I have never, in my childhood, I never seen any Tonga Gari. When I went to Mathura, Vrindavan, I saw Tonga Gari. And horses are with this, horses can't see anything else except this straight.
Thinkers.
You live there, take out that this thing, Arey, maybe little bit more creative. See, you see, why can't you engage the service of Pune University or some institution in Pune, authorize them on their behalf and see that they don't cheat. Idea is that why do you want this center under your supervision? So that a student don't cheat. That is the original authentic examination. They can do that. See, in various colleges, they have the centers for recruitment, for admission of the students. They have centers all over the country. Then assign certain person, okay, please go and see that supervisor examination. Why can't you do that?
Difficulty is that the UGC cannot supersede the.
We'll see that.
guidelines of the
You-
Supreme
But
Court.
we are
come
asking for a
across-
one-off exception, my lords, my friend. The main matter will be.
Mr. Nair also kindly show us, help us also to help you.
Yes, lords, I am ready to assist.
So
There
that,
was
see,
whenever-
what, is there any provision under the UGC? Where see, any act has a special provision to overcome any difficulties.
Please.
Why can't you find out some provision which will
Lord, there are-
enable us
there
to
are-
pass these orders?
I will also place it on record. Lords. One is the Ministry of Social Justice's own circular, which is filed along with the application.
Yes.
Secondly, my lords, I'll also place on record UGC's own guidelines, which they permitted during COVID.
Yes.
In COVID, they permitted online. So it's not inflexible.
That's an
Yes.
extraordinary
Therefore,
circumstance.
no, what extraordinary? See, we are changing what digital means. See,
Lord,
otherwise normally 10
May
years
I-
before, we won't be able to hear Mr. Nair. Nair would have come down from Delhi. You are in Delhi or what?
Well, currently, I must confess, my lords, I'm in Chandigarh today, but
But
normally
see,
I'm in
Chandigarh,
Delhi.
see, he's going all over the country. But because of the means of digital means, he can address us. See, we have to adapt to this, the benefits offered by digital means. So we'll hear on Wednesday.
My lord,
Please
may-
assist
may I
us.
pray, my lord, to whatever lordship has fallen from your lordship's mouth, my lord, can it be recorded so that I'm.
Mister, he's already recorded live streaming. You ask your UGC people to hear what he recorded. Everything is recorded, it's live streaming. Nothing to be, everything what we speak is all open. What Mr. Chamwa, what more recording you want? You want to,
So that
it's
I
already
can-
recorded in
I
YouTube,
can,
you
my
go
lord,
and
I
see.
Pointed advice.
You
from
can
my-
ask them, you watch the YouTube and see for yourself. that list the matter again on 15 favor, we'll see.
Grateful.
So yes,
Service is awaited, my lord, as per office note.
Okay.
To await service, my lord.
Okay. Have a service report list after
2 weeks, my lord.
2 weeks. Okay. Next.
Item 25.
25, yes.
Lordship, in respect of, respect number 1 is, public, waited. I think respect number 4 and,
Oh, service awaited.
respect number 1.
Huh?
1, 3 and 4.
1, 3. Have a service report.
1, 3 and 4.
Have a service report, huh? In respect of 1, 3 and 4.
3 appearing for 3.
Also, Baki, you are the, please, who are appearing, please, huh? So that hard so and so and hard Mr. Chomoy for appearing for whom?
University Grounds Committee.
Oh, you see, then 4, 3. Have a service report in respect to remaining respondent. Then next.
Item 26.
Yes, what is this Jyoti Mohanna?
My lord, we were not allowed to appear in the examination
Why?
conducted by the Guwahati University for master degree in distance mode, my lord.
Why?
As per your lords, because the plea they have taken in the affidavit, initially in the prospectus, it was not mentioned. In the affidavit, they have taken a stand that we have exhausted, there are 4 chances are provided, and the petitioners, the writ appellants before your lordship has exhausted the 4 chances. And pursuant to your lordship, last order, there was a direction from your lordship to approach the authority. Accordingly,
Have you heard in person? No.
yes, my lord.
Then-
They went, my lord, as
And
per my instruction, that the controller of examination, my lord, he has informed that he cannot do it of his own. If any direction is passed from your lordship, they will have no objection, my lord. That's what they have said.
Do you have any instruction in that regard like that?
have any instruction
If you please have it, then we can pass in the, if they can do it, let them do it.
They've already given liberty to hear.
My lord.
So you take the instruction.
My lord.
to get a, when? Next week or something like that? Oh,
Next week, my lord. Maybe on Monday, my lord, because
Monday.
any day subject to your lordship's convenience.
Next Wednesday.
Okay.
My
Wednesday.
specific instruction is that, my lord, pursuant to your lordship order, the appellants approach the controller of examination. And the stand was that if any direction is given from your lordship, they will have no objection, but he cannot do it of his own.
Okay, we understand. Yes. Wednesday.
My lord.
In the meantime, Wednesday again, Mr. Fukan will take instructions in this regard as to what had transpired after the appellants appear before the control examination Guwahati University. Yeah?
I'm obliged. Most.
Item 27.
Domon,
My lord, the IA is for delay, my lord.
how many days?
My lord, it's 219, my lord.
Oh, then we have to issue, who is the respondent?
Respondent government department, my lord, and
All are appearing?
Yes.
All the respondents have paid? Huh?
2 to 6. And appearing on behalf of 2 to 6.
2 to 6. And the state?
Last occasion appeared.
PWD, yes. PWD, 2 to
Separate
6.
standing council is there, madam.
Huh?
Separate standing council is there.
Then 7 is Commissioner Secretary Assam Finance.
Again, separates.
Anyway, doesn't matter. So we can, yes, some government can, and how much is then?
My lord, 219 days.
290. Why delay? Tell us.
My lord, earlier, my lord, paragraph 2, I have stated.
Who are you?
I am the petitioner, my lord.
No, in reply, what is your standing in the,
Earlier, my lord, there was a flood, my lord. page
Ah,
12,
then?
in Dima, Assam, my lord. There
Ah.
was a devastating flood, my lord.
So,
So annexure A and paragraph 2, my lord. I have explained, my lord, that in the flood, my lord, almost, my lord.
okay, I'm Mr. Lane Council for the applicant House Lane Council. The present application filed for contingent delay of how many days?
219, my lord.
9. The reason for the delay in filing delay has been explained in para number.
2 and 3, my lord.
We are satisfied with the ground assigned. We also, the learned council response also has not raised serious objection. Understand, we allowed the application. Contingent delayed. I allowed, yes. Next,
Item 28.
let the related, let the appeal be listed again.
My lord. Obligation.
This IA is for condemnation of 3 days, my lord.
No, earlier, condonation by the writ appeal was dismissed or what? And then, this filing number, okay.
That is a
Oh, filing number, okay, the filing, okay, that let the connected writ appeal be listed after registration, huh?
My-
Yes. Yes, what is this?
My lord, the
IA for what?
condonation of
How many days?
3 days. My lord.
3 days. Who is the other side? Who is opposing it? Huh? Yes, madam.
May I please, your lordship?
You
Mr.
ban.
Sharma
You,
is-
huh?
Mr. Sharma is legs in code number 23.
What is your name?
Sabina Yasmin.
Our miscellaneous counsel for the household, Ms. assisting, your counsel, huh?
S. Yes.
Your name is Yasin.
S. Yasmin.
Yasmin, assisting whom?
Mr. Mukesh Sharma.
Mukesh Sharma for the Learned Council, Council for UCO Bank. The present application has been filed for condoning a delay of 3 days in filing the appeal.
Read appeal, my lord.
Read appeal. So the reason has been assigned para number.
Para 5, my lord.
Having gone through the set reason assigned as many paragraph, we are satisfied and according to IA's conversion delays allowed. I dispose of, let the writ appeal be listed after registration.
Highly obliged.
Yes.
Supplementary list for hearing item 34 and 35.
34, Purnima, what is your friend Purnima? Malakar, Champa Malakar. Oh, that.
Yes, yes.
Yes,
First
yes.
question. My lord, I have gone through the entire judgment passed by the learned Central Administrative Tribunal. My lord, it appears, my lord, that it's a very reasoned judgment and there is no infirmity in the judgment whatsoever.
That we understand is very
My lord,
reasoned judgment.
my lord,
Very,
my
very
lord,
good
my
reasons
lord.
have been given, but does he have the
Yes.
jurisdiction to do that?
My lord, I'm coming to that point. Before going to that point, few dates are very important. If your lordships kindly note.
No, please tell us.
My lord,
For what these dates are relevant for what? Tell us.
my lord, the death of the wife of the husband of the deceased, my marriage, the marriage of the petitioner, which
Is
are
it
not
disputed,
disputed. Those
huh?
dates are not disputed. When, who was married when, my lord. So those dates are not disputed.
No.
And insofar, my lord, the question which has been posed that whether the honorable CAT at all has the power to declare the status of a marriage. My lord, in my humble submission, no, the honorable CAT does not have that power to declare that. For that, a person, a dispute has to be adjudicated in a civil court. Now, what the learned CAT has done in the instant case, my lord, they have not adjudicated on the status of the parties per se. Now, what CAT has done in this, in the the order which has been impugned, my lord, a dispute that arose before the railways. Once the person, person who died in harness, the question of pension arose, and there were two claimants. One, the petitioner; second, the respondent number 12. Both claims to be the wife of the deceased. I claim to be the first wife. The petitioner, he would also claim to be the first wife, whatever that will come later, my lord. So that a dispute arose. Now, when a dispute arose, my lord, what the railways, the respondent railways did, they formed a committee and it was inquired into. Now there was an inquiry on the issue of who is the first wife of the deceased. Now, pursuant to the inquiry, my lord, there was a finding that the petitioner is the first wife. That inquiry itself is perverse. I'll show how, my lord. Pursuant to the inquiry, there was a finding that the petitioner is the first wife, and hence the pension should be granted to the petitioner. And accordingly, there was an order passed, which was impugned by the respondent number 12 in the OA. Now, what the CAT did, my lord, the learned CAT did, CAT adjudicated on the matter whether the inquiry and the impugned order was perverse or not. That the CAT has the power to do as per section 22. My lord, and insofar lordship may pose this question now, whether the department can even venture into such an issue. Now, there are case laws, my lord. There's a number of case laws by the Honorable Supreme Court, where it is no longer res integra, my lord, that when a dispute, my lord, for example, if I may give an illustration, for example, my lord, in civil services, my lord, conduct rules, bigamy amounts to misconduct. Now, if a person is alleged of bigamy departmentally and a departmental inquiry is initiated, there cannot be he cannot question the inquiry on the ground that only a civil court can decide whether I'm married twice. Now that power is there before the department. Similarly, my lord, in the instant case when the issue arose, my lord, whether who's the first or the second wife, the department did an inquiry, and as per the inquiry, they found the petitioner to be the petitioner number, the first wife. Now that settles, I hope, my lord, that the question whether the CAT had the power, in my respectful submission, my lord, CAT had all the powers. CAT had just adjudicated on the impugn order, and CAT had declared that the impugn order itself is perverse. Now the question which would arise now whether who's the first wife or the second wife. Now for that, my lord, lordship may kindly take note of few dates which are not disputed by any parties, my lord. My lord, I was married on 27/11/97. 27/11/97. And
Pencil. 27?
27 of November 1997.
Yes.
Thereafter, on 20/01,
red light. Black. Okay, sorry. Is there? Yes, 27/11/97 then?
97 was the marriage between the deceased husband and the respondent number 11.
Respondent number 11, you.
My
What is that? What is the name?
My name is Sipu Khan alias
Okay,
Sipu
okay.
Malakar.
Okay.
On 20/01/1999, a daughter was born from the marriage, whose name is Chompa Malakar. Now, my lord, insofar as the birth of the daughter is concerned, that has not been disputed by the petitioner. There's the birth certificate, and admittedly, she was born on 21/1999 to the father who's the deceased husband.
Okay.
My lords.
And what is the third?
My lords, lordship would take note of another date, my lord, on 01/10/1999. The alleged marriage between the petitioner and the deceased husband took place. Now, my lords, 27/11/1997, when we got married, lordship would, my lords, consider that I am a Mohammedan. The deceased husband was a Hindu, my lord. Now, between us, my lord, there could not have been a Hindu marriage because both parties have to be Hindu. So the only recourse which was left, my lord, was marriage under the Special Marriages Act. Now, on 27/11/1997, lordship may turn to page 69 for a moment, my lord.
Yes.
69.
Yes.
There is an agreement that the deceased husband and my client are getting married. He is 26 years old at that point of time. I'm 24 years old at that point of time. That we are getting married and all that, if anything happens, I'll be, but it may not, that deed may not be, my lords, the sanctity of the deed. I'm not heavily relying on it, but nonetheless, there's this deed of agreement which has been signed by the magistrate, by witnesses, notarized. It's there. Now, what had happened, the ground, the railways and the petitioner, they are claiming is that we got the marriage registered in the year 2010 before the Registrar of Marriages, Special Marriages Act. Now, the railways and the petitioner, they misconstrued, my lord, that in a case where there's a special marriage and there's a certificate issued, my lord, there's a certificate issued, the marriage would be considered, the date of the marriage would be considered from issuance of that certificate, my lord. However, my lord, I'll take your lordships to the act. I'm just explaining now, my lord. Now, Special Marriage Act envisages two kinds of marriages. One, My lord, two kinds of marriages, my lord. One, under section 12, my lord.
See, Mr. Monto, we understand, we have understood what you are trying to say. The railways authorities, while trying to determine who is the first wife, they did certain exercise committee, then the tribunal found fault with that committee on whatever ground. Correct. So to that extent, according to tribunal can look into the correctness of the finding.
Exactly. That's exactly what was
Okay.
done.
But then can the tribunal go ahead, one step ahead and say, well, I found fault with this, actually it should be like this. Therefore, she is the first wife, not you.
I was,
Can-
I was
um,
anticipating that question.
So,
from the
so what do we do now?
honorable
What
bench,
do
my
we
lord.
do now?
My lord, if your lordship should
Yes.
kindly 5 minutes.
No,
more, my lord,
we'll hear you. Don't worry. We are not going to rush.
Very grateful.
We are not going to rush. We are not going to, we
My
are not
lord,
going
in my
to,
humble submission, my
there
lord,
will be
if-
no judicial
if-
tsunami.
if all-
No judicial tsunami, we'll hear you.
all
But
the
then
facts
we
are-
want to know what is
all
happening.
the facts are first, because I am.
Oh, Mr.
If all the facts,
No will be condemned, and everybody, there will be, you will be heard fully.
all the facts, if it is placed.
We
in the-
just wanted to hear, see, Monto, just to understand what is the problem.
Right.
And doctor first tries to understand what is the problem before he prescribe medicine. We are trying to understand what is the problem. Now, what medicine we should prescribe, what medicine we should, administer. We are trying. So we are trying to understand the problem. You know the problem because you are the disease. You know I am having this, but the doctor has to understand before prescribing medicine.
My
That's
lord,
what I'm trying to understand. So,
If all the facts are placed.
and
in the-
doctor asks not only the patient, their father, mother, son, brother, ki hol teyano ko. They try to, find, that's what we are doing, asking all the sides, trying to understand.
If all the facts are placed in the proper perspective, my lord, in my respectful submission, lordship should also arrive in the same conclusion which was arrived by the honorable cat. Lord, my lord, I'll just.
Okay,
place
then,
few
okay, then
facts, my
we'll
lord.
hear, continue, because see, unfortunately, there is another division bench
My
waiting.
lord, I'll just take
Today-
10 minutes, bullet
No, no,
points, my lord, bullet
Two-
points.
2:30 ho gaya na, so.
10 minutes, bullet points, my lord.
Because see, we have to hear Mr. Your 10
Sir,
minutes and
since
another
I've
10
already
minutes,
started,
20
my lord,
minutes.
Finish 5 minutes.
Correct. We have understood because there is another division bench waiting on the line.
Matter is not so easy, my lord, number of questions.
And the single,
And
at
my
the
lords,
single bench also will hear.
Yes.
Hear.
admittedly, when the petitioner got married, she was 14 years old. That itself is a void marriage. It is admitted fact, my lord. She was born on 85, she got married in 1999, when she was 14 years, 1 day.
Anyway, we'll examine that.
My lord.
We'll examine all those issues. Next week or something like that, on a hearing day, we can
On a
hear,
hearing
because
day.
today is not a non-hearing day, that is why. Some hearing day,
14th, my lord, if it's convenient for.
Either 14 or 16.
16 February.
16, 14,
16 February.
16.
Hearing day, my lord.
16, na? Hearing will continue on 16. On responsive, please deliver instruction on the matter. But who is this, Mr. B. Kaushik? His name is, they're busy. They're busy, huh? B. Kaushik. Hard, Mr. None appears for the respondent. Another opportunity granted, at least next week. Next,
Item 2.
Osit Baron.
May I please, Lord? My lord, I
Yes.
received order dated 5/12, my lord.
What is to be done today? Tell us. Notice have been issued or what?
No, my lord, notice was not issued, my lord.
Who is appearing for the other side?
My lord,
Standing Council Education, my lord.
Yes, Education Standing Council. Yes, Mr. Khotaniyar. Anything, any instruction?
My lord, on
Item
that
number
day,
two.
my lord, they stated before the court, they have received some instruction, my lord.
Yes, anything, Mr. Khotaniyar?
At number two, I'm seeking some time, my lord.
Okay. Okay.
AHMR Choudhury.
Mr. Khotaniyar prays for some more time to take instruction. List accordingly after 2 weeks. Yes, next.
My lord, that date-
Item 3.
date-
I will do after 2 weeks. Yes. Item number 3. Yes,
22nd
please for
March.
the other side.
My lord, in this case, my lord, the friend was.
Monita Devi, no? Monita Devi. Here also, my lord, I'm seeking some time, my lord.
Okay, okay,
My
Mr.
lord, the
Khotaniyar.
petitioner is retiring, my lord.
Huh?
Petitioner is retiring, my lord, in the month of September. Before
Do
that,
that
my lord,
before retirement.
Yes, my lord.
Okay, 2 weeks. Yes, next.
one more thing, my lord, the name of the respondent number 2, my lord, is wrongly typed as respondent number 3, my lord. Wrongly typed as my lord Tharindra Jijung. It should have been Suranjana Senapati. my
Oh,
lord.
we'll later on. Yes, next.
Item 4.
Abdul Kalam. Yes,
My lord, in this case also, my lord, respondents are directed to.
yes, Khotaniyar, you are appearing in this.
Yes. Here also, I'm seeking some time. my lord.
Okay, same order, yes.
Item number 5.
Partho Pratim, yes. Which for the other side? Anybody for the other side?
I've got some instruction once.
What instruction? Good, bad, what? Good, bad, ugly, what? Tell us.
Opening, my lord.
Huh?
After some time, my lord, can we take it after some time? I'll just.
Okay. Good news for him or no? Not good.
Hopefully.
Okay, we'll wait.
Item
Next, yes.
6.
Dilip Das.
The petitioner is a physically handicapped person.
Oh,
They have examined petitioner twice.
Six,
Last
no, six,
examined by medical board.
Dinat is on the way, Lord.
who?
For timing, Lord. Dinat is appear. For
Okay.
timing, Lord.
Next,
6 timing 7.
Nilupal.
7, Lordship, petitioner have to implement the present income and secretary, Lordship.
One, respondent number 1, so far I know from him, my lord. That is no more in the office, my lord. I may be allowed to take.
Okay, a petitioner to implement the new incumbent to the office of the.
Principal secretary.
Yes, next.
Item number 8.
Pranamika. Anybody for Pranamika? Yes.
In this, we need some time, my lord.
Pranamika, okay. After 2 weeks on the pyramid. Yes, next.
Item number 9.
Saram Das. Yes,
Earlier occasion instruction also.
Yes, I'm praying for some time. my lord.
2 more, yes. Further 2 weeks granted, yes.
Okay.
Yes,
My
next.
lord, 1 week, my lord. Kindly 1 week.
2 weeks.
Item 10.
Yes. Lalung Gaon, Krishi.
Yeah, my lord, non-compliance of the order dated.
Please for the other side. Anybody appeared? No,
No,
notice.
notice.
The rest are post with AD. 3 weeks, yes.
Item 11.
Mukul,
Non-compliance of the order, my lord. So
notice has been issued, notice.
No, my lord.
Notice, rest are post with AD 3 weeks, yes.
Item 12.
Yes,
Non-compliance of the order, Lordship.
notice,
Notice.
3 weeks, rest are post with AD. Yes, next.
Item 13.
Same order.
Item 14.
Dukhiram,
My lord, notice maybe, sir.
notice 3 weeks, rest are post with AD. Yes,
Obliged.
next.
Item 15.
Nijora,
Notice.
notice, yes,
Obliged.
3 weeks. RG. Yes.
Lordship, non-compliance of the order dated.
Yes, notice. 3
Item
weeks.
16.
Rest are post with AD. Yes, next.
Item 17.
Mukut, notice 3 weeks, rest are post with AD. Yes.
For admission, item 18.
What is this item? RL construction, anybody? Yes, madam.
Lordship, I'm still waiting for instruction, Lordship, not yet received.
File affidavit. Yes, Miss prays for some more time to file the affidavit. Yes. This
Obliged,
again.
Lord.
Yes,
After 3 weeks.
yes,
Timing item 5.
yes. Could you read the instruction? Item number 5. 5 and 6 due. 5 and 6. 5 years. Could you find out anything?
Yes, your lordship. In view of the above, as the
Ah.
name of the petitioner did not appear in the new part IS data. Up to the year 14-15, as per the decision of the joint committee, mine is dated so and so, for which SLC. That's why the joint committee did not recommend the name of the petitioner. My lord.
Oh,
That is the reason. So this thing was, direction was to give a reasoned order. They have given a reasoned order. They rejected it.
and Mr.
As to the
Land Council, how so, Mr.
If
No. For the response, who submitted the order will comply by passing a reasoned order, though rejecting the plea of the petitioner, be it as it may. Be it as it may, if the petitioner, be it as it may, this court of view opinion that cannot, the question of committing any contempt for the will not arise. However, if the petitioner aggrieved by the aforesaid dismissal of the, he may challenge the same before the appropriate forum. Copy of the is placed on record. You give a copy, print
I'm
out.
giving it. Just
You file it, challenge it.
a copy may be furnished. to-
Yes, copy will also be furnished to Mr. Land Council. It is condemned closed.
Deeply.
Item 6.
Yes, what is this, Mr.?
Malad, I am filing the affidavit on behalf of respondent number 1 and 2.
Okay.
Lordship will kindly see.
Give the copy. Malad.
Lordship, petitioner is a physically handicapped person. He has been examined by the medical board of Guwahati Medical College as per the instruction. On Lordship will find he report at page.
On Monday, we'll dispose it of.
Lordship will can say.
You file.
Today
No.
I'll give the copy.
Lordship
You file a
kindly-
copy, I will dispose it of on that
Yes.
day.
Lordship kindly see their action. Lordship kindly see the medical report by the medical board. This is a
Correct,
medical
we-
examination by the Guwahati.
we understand, we'll pass the order, appropriate order. Only
On
thing,
last-
let it be on record, that is why.
Lordship, on last occasion also, Lordship has passed the same order.
Is it so?
Lordship.
Malad, my
Oh,
affidavit-
appropriate order will pass.
Yes,
my-
Lordship.
My affidavit is ready. Malad.
Because
Just in
petitioner is
just in the
going to
process
retire
of-
from
just in the
service on
process of filing,
31
Malad.
three,
I'll
Lordship.
give the copy today. Malad.
Everything has been done
No,
from
Malad.
2019, Lordship.
No, Malad, even if this report, the percentage of disability, they are not in a position to assess the disability. Malad, while considering the case of the DPC has given a observation that the appropriate authority will assess the percentage of disability and accordingly he will be, his promotion, he has been already recommended for promotion, but subject to assessment of the disability percentage.
Lordship
And
kindly see the
APSC
medical board examination
APSC has
on
also recommended to
2012,
that effect.
2022.
APSC has also recommended his promotion to that effect. Lord.
Very
Now, From
good.
orthopedic patient has been examined, found restriction of right ankle joint, has difficulty in walking unassisted.
And 40% locomotive disability has been assessed anonymously.
No,
Where is it? Where is it?
no, there
Lordship
is
will
no
find
assessment.
the report. Dilip Das, male aged about 59 years, has been
Ah.
examined by the medical board, constituted by the superintendent of GMCH. Board anonymously recorded the following facts. Mr. Das has already been granted 40% locomotive disability since 2004. Patient has trauma in 2004 and
Ah.
treated for 6 months. So 40% disability has been assessed by medical board. Earlier, there is a disability certificate. Government has issued a unique certificate by the same medical board. This is the unique medical
Malad,
government of India, Lordship.
Let my affidavit come. or
Lordship,
Lordship may kindly
is it,
take up
is it
tomorrow.
right, Lordship?
Tomorrow, Malad. No,
If,
no
if a
problem.
person is examined time and again to assess the disability, after having the medical certificate from long back, it was renewed from time to time. This is the Lordship, the issued by the competent authority. This is a disability certificate issued in 2022
Malad,
by the medical board.
Malad,
There is a limit, Lordship.
to this certificate also, Malad.
Tomorrow we'll
Yes,
pass
sir.
the order.
Yes, yes.
We'll dispose it tomorrow.
Lordship, I am filing the affidavit today, Malad.
Whatever
Lord-
that,
Lord-
we are not passing any order. It is
Lordship.
up to you.
Lordship.
Tomorrow, we'll come up tomorrow.
Mr. Lord.
Lordship, kindly see, this is the certificate by the medical board. And it is from renewed from time to time.
Tomorrow we'll pass the order, yes.
Malad, my affidavit, I'll file today.
Whatever you do,
Lordship.
want you file, not file, it is up to you.
No, no, Malad, we are filing it. Malad.
You
We are filing
will do that. We have already passed
And
the order.
Lordship has
Yes.
already called for the records of the original cases where disability certificate has been exhibited.
Okay, list tomorrow.
Yes, yes, records are there.
Yes, next.
This